The Commonwealth of Massachusetts has weaponized the witness intimidation statute to silence an independent reporter, an investigative reporter, a reporter who let the world know Karen Reed's case was actually happening. Today, Mark Bederow is going in there, see what he can do. And we're going to follow it the best that we can. So let's dig in. Good morning, everybody. Happy Monday. This is Defense Diaries. I'm your host, Bob Mata, and as always, I'm joined by my beautiful and brilliant co-host, sitting in the dark because she's in our daughter's room who's still sleeping. So it's pretty eerie looking. We can vaguely see her. But what's up, babe?
Hey, babe. Hey, y'all. She's so adorable. I can't possibly wake her.
Wow. All right. Did you get that thing? All right. So we're gonna try to stream it through Law Girls Not Attorneys. They always give us the go ahead to use their stuff, so we're always thankful to them. Make sure that you're going over there, giving them a sub. They're damn close to 5,000, so let's help get them over the hump there. So, do you have that thing?
She's 20.
Yeah, she's 20. She's gonna be 21 in 2 days. Oh no, 20 in 2 days. All right.
I sent it to you.
Oh, you did? All right, hold on. Let me see.
See if I talk soft into the microphone. She won't hear me.
Okay. All right, Judge is just taking the bunch. We'll get it up.
The bunch. Nice.
Oh, sorry. Oops. Okay. All right.
You can't anger the beast.
She does get angry.
No, but she's a sweet beast in the morning.
All right.
Sound, because I think he's talking.
All right.
You haven't registered for the SJC. Per the SJC rule 1.19, rebroadcast is inappropriate and unlawful. So,
Your Honor, I'm happy to go through in the order that you set forth in your order.
Sure, let's
I have some discussions with counsel on some of the issues, and I don't know if you prefer to hear that first or.
That's on the discovery issue.
Yes.
All right, we'll come to that last. If you've reached a resolution, that's fantastic. But let's deal with the motion to dismiss first. Mr. Bederow, your motion, I'll hear you. You might want to concentrate on a couple of things to start with. Number one, there was already a fully litigated motion to dismiss both under McCarthy and under Odell, in which Judge Doolin drafted a 36 or 37-page decision, which is an exceptionally fulsome decision from the court, in which he found probable cause for the majority of the indictments, but dismissed all of them, including the one that seems to be at the heart of a number of these motions, that is to say, against Mr. Proctor. So the first issue is this. Under Rule 13, and under Commonwealth versus De Los Santos, which I'm sure you've reviewed, which is 492 Mass 242, 2023 case, if the matter was not raised, it's considered waived. So tell me why. I understand the issues with Ms. Peters may have been disclosed post that hearing, at least to some extent. Tell me why the other issues aren't waived under De Los Santos and Rule 13.
Rough start.
Was there another issue, Your Honor, you wanted me to focus on?
You know, that's to start. Then we'll get to the substance of it.
Thank you, Your Honor. Judge, it is true that many of these issues existed in a grand jury transcript and motions that were ruled upon by Judge Doolin. That is correct.
Right.
And Rule 13 does state what it states, but there is case law which also states that the court does have the power to reconsider or reevaluate issues which were not brought to the court's attention. Now, in this particular case, there's no question that issues that related to the wiretapping, the uncharged wiretapping, for example, could have been raised. As the issues related to some of the videos in this case, the name changes, the court should be aware that for whatever reason, that snuck by everybody, including Judge Doolin, including Mr. Cosgrove and some of his filings. And as soon as that was picked up, that is something that we put into writing and addressed right away. The reality is the grand jury in this case was not proper. I mean, I think, and I'll get to that in a minute after answering Your Honor's question about the waiver issue, but in terms of the form over substance.
Well, it's not really form over substance. It's substantive. Rule 13 is substantive. Della Santo is substantive. And there's a reason for that. And the Commonwealth in their opposition has pointed it out. It's because you can't keep retilling the same ground over and over and over. At some point, you got to move forward. So it's not just form over substance. So you got to give me a little bit more than that.
Well, Haskell permits it, Judge.
It does at the court's discretion.
Right.
But you got to have a reason.
Absolutely, there is discretion of the court to ultimately decide what should be done and what shouldn't. But where the court sees prejudice, the court respectfully should act. Now, again, with the videos that were mislabeled, the Commonwealth shouldn't benefit from what is clearly deceptive conduct in terms of renaming items that, again, nobody saw. Judge Doolin himself referred to the names by their improper name during his ruling. Which
presumes that Judge Doolin was aware of those names and didn't find them to be of any substance because he watched the actual videos.
I don't know. Well, the actual videos that were presented to the grand jury, Your Honor, were 40-second snippets of hours-long video, which were not grand jury exhibits. So respectfully, there's no way that Judge Doolin could have watched those videos because Mr. Mello
well, he watched the clips, no doubt.
Yes, but the clips are tiny segments of larger videos that, again, when we get to the real meat of what I want to discuss with the court, would show the full context on the critical issue in this case, which is only one, and that's Mr. Kearney's intent. That's the only issue that was really before the grand jury, and none of that was seen in Judge Doolin's opinion because none of that was before.
Because it wasn't raised.
Well, it wasn't raised, but it wasn't known by anyone. Now, again, could it have been? Yes, but the court has the discretion.
But it was known because Judge Doolin referred to it by the titles that you think are inflammatory.
Yes, those are the names that he was provided by the Commonwealth that were changed. Those were the improper names that the Commonwealth knew in advance were not the proper names and were changed. And ultimately, Your Honor, as a matter of discretion, there's no prejudice to the Commonwealth here by having this. I suspect this argument, which is a fair argument to make, is their primary argument because they don't want to talk about what actually occurred in the grand jury. And the fact of the matter is everybody sees it, everybody knows what it is, and it ought to be addressed. If there's no prejudice to the Commonwealth, the court should hear it. No indictment should be tolerated when it is rife with misleading evidence, distorted evidence, statements of prosecutors and police witnesses saying, in my opinion, it was this man's intent to commit witness intimidation. That's outrageous behavior in front of a grand jury. And when you get down to brass tacks in this case, that's all that this is about. They misled the grand jury on the only issue that matters, which is whether Mr. Kearney's intent was to commit witness intimidation or not. The conduct at issue is open and shut. It's the videos, not the videos that were submitted into the grand jury. Those are tiny snippets. The conduct and the context of Mr. Kearney's intent are contained in the actual videos. And what you have at this point, it's very similar to Odell itself. In essence, you have prosecutors cherry picking 30 seconds they like out of a 2-hour video and saying this proves his intent was to intimidate witnesses, but not letting the grand jury have access to the other 2 hours, which show him saying, I want to bring awareness to a miscarriage of justice involving Karen Reed. I'm petitioning the government to address that. I believe that these police officers are corrupt. We're doing this to bring justice for these people. The grand jury had a right to that. And the best example of this, Your Honor, to get a full picture of what you're dealing with is all of the picketing counts in this case are from this so-called rolling rally. That entire video, the whole rally was recorded, video recorded by Mr. Kearney, literally the crime, if you will. They didn't introduce that video, but what they did do was admit 58 seconds of the rolling rally, which the honest name of that video on YouTube was Canton, the rolling rally justice for Karen Reed and John O'Keefe. They took 58 seconds of that video. They introduced it as the title of that video is Don't Feel Sorry for the O'Keefes. That's not evidence, but if you look at the grand jury testimony and the transcript, the way Mello and Tully did this is Tully said, the name of the video is Don't Feel Sorry for the O'Keefes. It's contained in a folder literally titled Intent, literally. And he did that approximately 30 times throughout this proceeding, told the grand jury, this is proof of his intent. They literally asked questions and answers that talked about intent. They played 30 to 50 seconds of this video where he literally says, don't feel bad for the O'Keefes, but yet don't present the video of the crime. Why, what prosecutor?
But their allegation is that is the crime.
Your Honor, again, it goes to Odell, literally. They can believe anything they want. They can allege anything they want.
But they're not alleging that the rest of the rally was intimidation. They're alleging those clips are the intimidation.
Right. But, Your Honor, when they present it to the grand jury, it's tantamount to what happened in Odell with the police report, where we decide we like sentence 1 because we think it proves his intent, but we don't like sentences 2, 3, 4, and 5. So we're just going to keep that from the grand jury. In Odell, that was deemed to have impaired the integrity of.
But a police report and a video are very different things. We often encounter situations at the grand jury where they have hours and hours of videotape, but they only play certain clips. But
they didn't tell the grand jury it's available for you. The point is they told the grand jury the name of the video is jury influence is another one, which was actually titled Protesting Michael Morrissey. Big difference. A video that was 5 days after DA Morrissey made a statement to the press, which was improper. He gives a 2-hour video and says, I'm trying to bring awareness, trying to do this and do that. And this is in August of 2023, well before trial. And says, absolutely, I want to influence the public and the jury pool. And they take that little snippet. They may have a theory that enables them to say, we believe that's proof of his intent. That's fine. What's not permissible, though, is to rig it in the following way, to say, literally, Your Honor, I can read to you, there's a literal question and answer, which is very important. For example, on December 19th, question from Mello to Tully before he plays all of these videos, which are misnamed, cherry-picked. Do you have any knowledge of incidents which you feel are intimidating of a witness with respect to any particular witness? I do. Question, those are on video. Answer, they are. Play those for the grand jury. So now we've just told the grand jury, I think his intent was to intimidate witnesses. Then what Tully does again and again through direct intentional questioning of Mello, it's not volunteered, is to say that these videos are named inaccurately, and they're in the memo. You've seen them, page 62 and 63 of the motion, all the times that they did this. They play the snippet, and then when it's over, they tell, or before they do it, they tell the grand jury, these are from a folder marked intent. He didn't do that.
Yeah, but slow down, Mr. Bederow. You have to give the grand jury some credit. The grand jury understands that a defendant is not going to create a folder which says intent. They had to know the prosecution created it.
That's my point.
Right, but give the grand jury some credit. They understand that.
Your Honor, the point is, respectfully, when a police officer tells the grand jury, in my opinion, this man's intent was this. I have a folder with proof of his intent. It came from that folder. I'm going to tell you a false name of the video that I renamed, or some third party working with him renamed, whichever the case may be. And then you don't tell the grand jury that this was renamed by us, put in this folder by us. I'm playing you 30 seconds, but I'm not going to give you the rest of the video. And I would refer the court, this case is cited in the memo of law that went with the motion, Bleakney, the appeals court case, not the SJC, the lower appeals court, where they cherry picked a portion of a statement of a defendant, left the full flash drive in front of the grand jury, but never alerted them to the contents of it. And in that case, the appeals court found it impaired the integrity by hiding the ball. Here,
If you're going to go there, Mr. Bederow, if you're going to go there, then you got to talk to me about Shaquille Brown, which is the SJC, in which the prosecutor dumped in at least 100 pages of prison records, in which the prosecutor dropped in telephone logs, all of which had never been looked at or never been read. And the SJC said, well, it wasn't so good, but that's okay because it didn't change the analysis of the evidence, which takes us back. And this is the
yes, sir.
Slow down. This is the difficulty that you have. So this is why De Los Santos does matter, and it is substantive, okay? This is why Rule 13 is substantive, because you already had a very thoughtful, all right, a bulwark, if you will, from a judge, all right? A very thoughtful judge who examined in detail the entirety of the grand jury, found it to be free from prejudice, and more importantly, found that the evidence was substantial enough to issue an indictment. So that brings us back to the court's analysis in Shaquille Brown, which I'll give you the side if you like.
I have
490, 171, and I'm very familiar with that case. All right. In that case, the court finds clearly they shouldn't have done any of those things, but finds it didn't impair the integrity of the grand jury, and this is why De Los Santos is substantive, because Judge Doolin's already made that determination. So you got to get around that.
I'm happy to, Your Honor. The difference with Shaquille Brown and Judge Doolin's decision and why it matters here is context is everything in terms of his intent. Oh, he is
but in Brown, they're trying to show joint venture, and they dump in prison records they haven't even read.
Judge, I'm bringing it to this case, okay?
Yeah, but this is the SJC telling you this.
I understand that, but the facts here matter, and the context matters. And just because the prosecution has, a one-sentence explanation of what they say, and a grand jury ultimately determined was proof of intent after they were told what his intent was by the prosecutor, by all the reasons that we spoke about earlier, context is everything. If there is a long statement that is talking about protesting and bringing awareness and making jokes and all kinds of things, and there's a comment in there that I like that comment, just give the grand jury the whole thing. The role of the grand jury is fact finder. The problem in this case is that Mello and Tully decided to be prosecutor, detective,
grand jury's not really
fact finder.
Grand jury's not really fact finder. Grand jury's more of a gatekeeper. But go on.
But they have to judge respectfully. They're not. They have to find the facts to support an indictment. And in this case, they literally did, but they were misled. And context matters. A grand jury is entitled not to everything in the world. It's clearly not a trial jury. We all understand that. But when you do it, you have to do it fairly. And they put their finger on the scale with evidence of his intent in terms of what they told the grand jury, what file it was in, the length of the video, the full context of the video, the uncharged crimes. Judge, the last piece of evidence in this case that they put in the grand jury was an uncharged crime of, again, the rolling rally video, which they didn't see fit to give the grand jury, which makes no sense if anyone's prosecuted these cases and put in cases in the grand jury.
You know we can't hear that, right, babe?
Can't hear it? Shit.
I can't tell if she sees me.
Oh,
that said this is punishable by 5 years and never gave a curative instruction, never withdrew that charge. De Los Santos or not, Your Honor, the question is, at what point do we not avert our eyes to what they did? They need to do it fairly.
But the judge has already looked at that.
But he didn't see that, Judge. If you look at Judge Doolin's decision, none of that is addressed because he, like everyone else, was misled. Moreover, Judge, I am focused on the grand
Why
jury.
is it so small now?
Obviously, you're focused on. There was a second component to the motion for extreme government misconduct, and there's no reason why.
Well, I'll listen to you on the Peters stuff. I mean, I think if Peters wasn't known to you, I think that's fair to discuss.
Well, it wasn't. The whole point, but before I get to the merits of that motion would have been made anyway. So that, because we can't.
oh my God. Hold on.
What?
Do you hear it?
No, we can't see it. You got the wrong screen up, dude. You got it paused on a mini screen in front of us. Fix your shit.
All right, hold on.
Fix your shit, man.
All I did was to share this one instead, and it fucked it all up.
Yeah.
All right, we'll rewind. Everyone breathe. Everyone calm down.
We're like, wait, the judge's mic fucking cut out. Fix your shit, man.
All right, this looks like it's it. All right, share this tab.
Did you see a mini screen? You haven't Okay, you fixed it.
All right, I think I fixed it. Let's go.
After
Volume.
numerous specific, very specific Brady demands and Discovery Rule 14 demands, they could not have been more specific.
Somebody understand, what is the basis that you're asking me to dismiss? Is it for the discovery violations or for the substantive violations?
What?
Can you turn off the comments, Bob?
Motion.
Oh,
The indictments ought to
Oh,
dismiss
I think you can.
impairment of the integrity of the grand jury proceeding, full stop. As far as the second component, based upon the lack of discovery, that prejudiced us from filing a full-throated motion the first time. The court should consider that in even hearing the grand jury component of it. But in any event, if the court is wondering why discovery was ordered to be completed in early 2024, and all these demands were made before, during, and after that time period, and stuff that is responsive is showing up in July of 2025 that we turn out to learn was in the possession of every single prosecutor on these cases in December of 2024, which is before the motion was filed in front of Judge Doolin. What is going on?
I consider these to be two separate categories. That's why I started with the issue of Peters may be something which is outside Rule 13 of the De Los Santos analysis. Just want to give you an open field to discuss that.
Okay. Excuse me, Judge. The evidence that exists or no longer exists from the third party that the court mentioned is extremely prejudicial to the defense. There is a strong argument that could be put forward if there were to be a trial in this case that this investigation was biased, it was shoddy, and that involves any number of things, one of which includes, from our perspective, which is a shockingly close relationship between a private civilian, Peter, who you mentioned, who has a hatred of Mr. Kearney that is beyond adjectives that I could even provide this court with. Not only that, this is a witness who has falsified evidence against him. Literally, this is not in dispute. It's in the motion. Has forged court filings to try to screw him in part of their fighting during their lives, has attacked witnesses for the Commonwealth, Alberts, and tried to get him to say bad things about them when she in fact defamed them. And this person was basically holding Mr. Mello's hand. These are the messages that we got, amongst other things, telling him what to do. And when we got that affidavit from Tully, oh, well, I didn't open or click on any of these links. That's a problem for one reason, because they were in their possession, custody, and control, and ought to have been turned over. And what was contained, we don't know. But there has to be under Neal a reasonable basis to believe there might be something useful. And the reasonable basis you have is that the person who provided it to Tully that he claims he never opened has committed forgery, fraud, deception, and crimes against him. She's a dishonest person who is working hand in hand with the prosecutors in this case. Now, Tully says, I never opened it, and now the links are gone, and we were told in filings, it's been dismissed, it's been deleted by a third party, which presumably is Peter, and what are we supposed to do in now finding the evidence to support that defense? Just assume it's nothing helpful? Why would we assume that when this woman is bent on destroying him and commits fraud? What's that?
Isn't the shoddy work that he never opened?
That's amongst other things, but I said to you, Tully said that. That's not what Mello did. The emails that we got too late in the process literally show Mello and Peter talking, and he's asking her help. How do I open this? And Mello says, gee, thanks. He literally opened it. Opened what? Where is it? Tully says, I never opened it. It's deleted. Mello, very noticeably, never submitted in all the time the prosecution had to respond to the motion. And if the court remembers, they got many graces and deadline extensions to file, never submitted a sworn statement explaining any of this. What we got instead was a hearsay statement where Mr. Cosgrove, and I say this with due respect to Mr. Cosgrove, was essentially cosplaying as Mello, saying, this is what it would be. That's not evidence in response. What was required is something from Mello under oath, and we've never gotten that. And that's very important too, Your Honor. One of the things that we asked for in the motion is, as an alternative, a hearing. Okay? If this was intentional, the court should factor that in. Now, how can the court make a finding whether this was intentional or not without hearing from Mello, Tully, Peter, anyone else who may or may not be involved in this?
How does this affect the grand jury presentation?
Well, Peter,
I just want to see the argument. I'm not.
as far as the grand jury goes, it's either Tully or Peter who renamed these files. Now, Tully knew the full name of the files.
But according to Tully, he doesn't open it. So I'm just trying to. You may have a separate argument. I'm not saying you don't. Okay, as to what the relationship between Mello and Peter was or was not. I'm just trying to make sure I understand your argument. Is this part of the Odell, or is this some separate motion?
Well, on some level, it's a hybrid. I mean, there's clearly the Odell component.
I gotta understand what that hybrid is,
Right.
Council.
No,
You give me kind of a mismatch here with all sorts of stuff in it, and I'm trying to sort it out.
Judge, there's a standalone Odell motion, clearly, about impairing the integrity of grand jury proceeding. We also filed,
But how does go on, I'm listening.
there is a second motion to dismiss for extreme and egregious government misconduct based upon.
I beats me, which was a separate motion to dismiss based on what you filed.
No, Judge, it's a second point.
All right, this is the problem, what you filed. We'll discuss that already. I can't discern that there's a second motion to dismiss. It looks like a big Odell.
Judge, we don't know what missing evidence we didn't get. And the argument that was put forth in Mr. Cosgrove's response to this was that if you don't know, then there's no obligation for us to turn it over because there's no reasonable possibility to conclude that it would be favorable to you. And the point is, when it's evidence that was deleted, that was reviewed by Mello, Tully claims he didn't. and it comes from a source who hates him and commits acts of fraud and forgery against him, there's a reasonable basis to believe that something wasn't right in that evidence. We don't know. And this woman was assisting these people back right before literally days before the grand jury, explaining to Mello how to use the evidence. What is that evidence? She sent a folder titled Intent. That may we don't know, but that may very well be the clips, the change names. She'll probably deny it. She'll go online and deny it and scream and yell about it. Tully says I never looked at it. Mello is unheard of. He just disappeared in the wind. There's no sworn statement from him. These people at a minimum should be called in, take oaths, and let's get to the bottom of it.
I'm gonna get a better motion than like that. Mr. Cousins, what do you got to tell me?
Want me to just go through it? Sure.
We just think this is important.
Okay. First, whenever I hear counsel use the word jury picked, what that means to me is the Commonwealth picked relevant evidence to support the charges it was looking for. I don't have any real answer. I don't deny that that was what, in this case, Mr. Kearney said and did and put on the air.
Why not give them the whole video?
I'm sorry.
Why not give them the whole video? Say, go to Mr. Bederow's point. Why not give them the whole video to watch and play them selected clips? This is often the case.
I don't know what the reasoning was at the time, Your Honor, but if you look at the chart that Mr. Bederow includes in his motion, his affidavit rather, it runs on for about 3 pages. There's lots of videos. They tend to go about 2.5 hours each. If we give them the whole video, there is lots of other material in there that language used by Mr. Kearney, whatever, it could be construed as prejudicial. I'm sure Your Honor has already heard about reference to the O'Keefes, and the Commonwealth introduced this, and then they didn't indict him with respect to intimidation of the O'Keefes, and this was entirely inappropriate, et cetera, et cetera. I'm sure if Mr. Mello had put in 25 whole videos, we'd be getting an argument that all kinds of prejudicial material was put in, and that the Commonwealth should have simply chosen what was relevant to the indictments. I have to say, where's the beef? I keep hearing about stuff being taken out of context. If only there was the context, if only the whole thing had been shown. The defense has said, the defense has read my response, it said, Your Honor, and one of the things I said was, where is it? Where's the submission to the court? These are the things that if only the grand jury had viewed them, as Your Honor is now capable of viewing them because we have submitted them, and certainly Mr. Kearney has access to his own video, he would have put things in a completely different light, and here's why. You don't have anything. There may be some things in the entire videos that for example, Mr. Bederow says, at one point Mr. Kearney talks about how he's going to expose corruption or something like that. Mr. Kearney could have 16 different motives. People have more than one reason for doing things, for putting something in. Some of those motives may be good motives, but those motives are irrelevant. All the Commonwealth has to prove is that one of his motives was to intimidate those witnesses. That's what's relevant. Furthermore, I think, as Your Honor alluded to, we can infer a certain degree of sophistication on the part of the grand jury. Nobody watches even the evening news and sees a snippet of a Trump press conference or something going on in the city of Boston or an excerpt from what's going on in court and leaves under the delusion that other things weren't said, other things weren't happening. They understand that the news media selected what they considered relevant and showed that. In fact, I think that's what Mr. Kearney does on his own broadcasts. People sophisticated based on years of watching news shows and years of, at this point, watching the internet. There's nothing to stop a member of the grand jury, and for each of these witnesses, grand jurors have an opportunity to ask questions. And if you've read the grand jury transcripts, you know they did ask questions. And they certainly could have said, you know, you're only showing us a snippet here, we'd like to see the whole video. Nobody did that. Nobody.
We didn't put this on the grand jury to make sure that he gets a clear presentation.
No, I don't think we're putting it on the grand jury. I'm simply pointing out that in addition to the other points I've made, the opportunity was there. Nothing was being concealed. I think the practicalities of presenting the grand jury with however many hours it would have been, 26, 46, however, these shows of Mr. Kearney's run about 2.5 hours, would be somewhat absurd, frankly. I think the Commonwealth's obligation was to show what was relevant, and that was what we did.
Tell me about the issue, your thoughts on the issue, Ms. Peters and Mr. Miller.
All right. With respect to Ms. Peters, I want to make a couple of points. One is Mr. Bederow raises this issue of the prior federal court suit, which Ms. Peters apparently admitted to having forged a document or something of that nature. Well, Mr. Kearney would be aware of that because he was involved in it. But there is no reason why the best of prosecutors, when somebody comes to them with information, they may check out the information, which is what was done here. People went and looked at the broadcasts that they were pointed to, why they would go back and screen for federal court cases to see if the witness had previously been involved in a federal court case. It's not a search warrant where you're trying to establish the veracity of the informant, and maybe you do some research in that case, although I think it would be rare that that kind of research would be done. So the suggestion that the Commonwealth knew or should have known that this witness was tainted in that respect, I think is somewhat absurd.
To the best you have, do any of the Peters materials, were any of the Peters materials presented to the grand jury?
The Peters materials were presented to the grand jury in the sense that there were a couple of audio recordings that were obtained from Kate Peters, which Mr. Lieutenant Tully could not find checking independently, because the theory was that Mr. Kearney had taken them down and had replaced them with different videos in which he had intercut a warning that was not actually there originally, that the conversations were being recorded. One of those.
This was the wiretap, which didn't
Yes.
happen.
Right. So those are the only two. The rest of them, whatever was brought to Lieutenant Tully's attention, and I can't tell you the extent to which they were brought to attention by Kate Peters, or the extent to which they were brought to attention by the victims in this case, who are obviously not happy with some of Mr. Kearney's broadcasts about them, or by both. But in every single case, Mr. Tully's representation is that he himself went to the internet, looked up the broadcast, recorded it himself, or caused it to be recorded by somebody in the office. I have to say this predates me, but I have no reason to doubt that representation, and presented them to the grand jury. And I would point out to Your Honor, to this moment, there has been no representation that any portion of the videos that the Commonwealth showed, which we presented to the grand jury as things that Mr. Kearney himself had recorded in a broadcast, were not genuine. There's only been this argument that, well, they were taken out of context, if they saw something else, the jury might have thought something different.
Was the grand jury, did it, I should may have noticed, the wiretap indictments, no video, or were they withdrawn?
We didn't proceed, well, on.
Or did they not ask for a vote? Actually, is a better way to put it.
Well, on the Gaetani wiretap indictments, those were issued, but that complaint was.
Yeah,
was
not worried
dismissed.
about that.
So that leaves us with the Scanlon presentation. And what happened was, after the presentation was made, an issue was raised in mind of an issue was raised with the prosecutor as to whether, in fact, a Norfolk County grand jury would have jurisdiction. Mr. Scanlon, having been, I believe, in Suffolk County, at his end of the conversation, and I believe Mr. Kearney was not in Norfolk County at the time either. So there was some thought that maybe, as I understand it, maybe as Mr. Mello would ask Mr. Marcy to give him self-appointed as a special prosecutor in Suffolk County for the purpose of seeking and drugging it. But it was never pursued. With that in mind, the Norfolk County grand jury just expired without anything further being done. So nobody ever went in front of the grand jury and said, this is withdrawn, but at the same time, no true bill was proposed to the grand jury relative to this. Yeah.
Just never asked for a vote.
Never asked for a vote.
Any more you want to tell me?
No, I'm content to rest on my memorandum. I'm not sure I have any questions.
Mr. Bederow, going back to speakers, because I'm struggling to understand exactly what your basis on Peter's evidence is. Is the loss of exculpatory evidence? I don't know. You tell me, because again, the motion comes in as an Odell McCarthy sort of, and then it goes on for many paragraphs. It never really tells me much about why this is important. So, is it an Odell, or is it a Commonwealth versus Willie loss of exculpatory evidence? I gotta know.
We don't know what Peter evidence ended up before the grand jury because nobody seems to have it. What I can tell the court is she provided a copy of a Scanlon alleged illegally wiretap call.
Which isn't part of this indictment.
No, but to get to the point where they just said on the Scanlon evidence, we just never asked for a vote. What they never did is what every prosecutor should have done, which is instruct the grand jury, disregard that. They didn't do that. I mean, that kind of just slipped by in that exchange that was just had. You put forth uncharged crimes of wiretapping and actually tell the grand jury this is punishable by up to 5 years in prison for whatever reason. It doesn't matter. You choose because you think there's no jurisdiction or not. What Mello was obligated to do as the legal advisor to the grand jury with a duty of fair dealing, not to be an advocate, but a fair and honest broker, was to tell the grand jury, you must not consider any of that. You should not consider that evidence. You should not consider any possible penalty. So where did that come from her? We don't know. We also know that she sent evidence to Tully and I believe also Mello saying, I have taken clips from videos which show his intent in a folder named intent. We don't know where that
Let me
came
try to separate this out. I'm trying to understand your argument. Very fair. Okay? Doesn't sound like there's any argument here this loss of scope between evidence.
Correct.
All right, so we can take that off the table. Right?
Yes.
Is that a yes or a no?
Yes.
All right, so I don't need to worry about that. So what I'm now left with is the argument that the information, the only information that we seem to have right now with regard to Peters is the Scanlon non-indictment, right? Does that seem about right?
Well, and sending clips from videos in some folder named intent to Tully. That is,
We don't know that any of that got in front of a grand jury.
we do not know if that's literally what he is. Correct.
So what we do know is that the Scanlon information got to the grand jury.
We believe so. I mean, I can't tell you if they took her version and found it
Well, we know
out.
there was testimony about that, or evidence about that.
There was testimony of that uncharged crime that was
So
just
now,
left
what-
there.
I'm really trying to hone down your argument, so I can get my hands around it. All right? Now what we're left with is the question of whether or not the grand jury was, under Brown, tainted by the inclusion of that evidence. It's a high standard, really difficult, given Judge Dible's findings already. Or whether or not Mello had an obligation to instruct the jury on the law about that now withdrawn or not pursued indictment. Does that summarize the argument?
It does, and Your Honor, I can't fathom a world in which a prosecutor,
I'm just trying to make sure I understand the argument. I don't need further argument on it. I'm just trying to figure out if that's the argument.
of course, he should have instructed the grand jury to disregard prejudicial uncharged crimes, which could result in somebody going to prison. Yes.
But I still have to go back to the Brown issue, of whether or not it affected the integrity of the grand jury.
You have to determine whether it affected the integrity and ultimately whether it mattered. And, in terms of, did it probably influence the grand jury, the Mayfield standard, something else the court should consider about whether any of this matters. In March of 2024, Mr. Mello took another shot at grand jury involving Mr. Kearney and Karen Reed for essentially,
But not this grand jury.
no, but
All right, that we don't need to go there.
Your Honor, if I can have 10 seconds of leeway, none of the misconduct occurred in that grand jury. And what happened? The same allegations, same type of evidence, and that case was no bill.
That's a whole different ball of wax.
The point is, could it have influence? We don't know.
I'm not going to guess about the grand jury presentment that I've never read.
It's a good point, though.
It involves a far different set of facts than this, all right? Whatever, I don't know the details of what happened or didn't happen between Mr. Kearney and Ms. Reed. I don't know, and frankly, I don't care, okay? What I care about is this grand jury, okay? And much of that communication back and forth, allegedly with Reed, allegedly with Reed, it's all before me. I'm not going to draw an inference from that. I can't. You know that.
I'm not asking, because the same videos.
It's just a kind of.
No, Judge, I'm not talking about anything other than it was the same video evidence and Tully talking about the same things and
I'm going to
admittedly,
guess there was a whole lot more to that grand jury than these videos.
not much.
Not much.
Whatever. It's not what I'm not reviewing.
Understood.
I'm not reviewing it. I don't have access to it. So I can't draw a conclusion as to whether or not how it compares. So that's
I mean, I guess that's true.
the last place I want to go down the road is
Understood.
figure out any interaction with your client, Karen Reed. That's a no part of this trial.
It's cold in here.
Okay? All right. Anything else you want to tell me about this?
One other just response to something Mr. Cosgrove said when the court was asking him, why not just play or give the grand jury the opportunity if they so choose to have the videos? And the response was, well, they could have asked. I
I didn't put a lot of stock in that, so I wouldn't spend any time on that.
whatever they don't know. And the last point, Your Honor, is why rename the videos? Why say it comes from the intent? Why offer the opinions? It's to put their finger on the scale and to say, we believe he did it, you should believe he did it, and that's improper for a prosecutor to do as a legal advisor to a grand jury.
Fair enough. All right, I'll take it under advisement. Shoot.
I just
Wait,
wanna
pause.
point out
Pause real quick.
Commonwealth's perspective, the whole Scanlon argument.
Because I just don't want to forget this. If you see what Bederow did right there, he sort of shift gears because the judge was like, hey, we're going to give the jury the benefit of the doubt. I mean, the grand jury, the benefit of the doubt that they're not fucking idiots, right? And they don't think just because it's in an intent file that the defendant created a file and called it intent. So Bederow sort of shifts and he's like, all right, well, he was putting his fingers on the scales of justice because he's like, hey, this is our case. Look at all this stuff that we have to prove in the intent element. So I just, was noting how he sort of shifted in light of the way the judge was seeing it. And I still think it was a fair argument and a strong argument that, that Bederow was making. Even
Yeah, I mean, he's going up against a hot bench here this morning. I mean, the judge had a certain mindset when he got on the bench this morning, and clearly it was that Doolin had, in terms of his prior order on the case, where many of the counts were dismissed, and he's kind of standing on that without getting to really the substance, which I'm sure Mark is disappointed. Like, Mark just wants to make the argument, and the
Right.
judge just really isn't letting him get to it. And some of it is the problem that can't pinpoint some of the things that Kate Peters did, but you get the overall vibe, that she was the one driving the train. Like she was the one supplying information, and then they took that information and framed it in such a way, by using things like an intent file. Oh, well, here's all the intent. This is what he was really doing. He wasn't doing investigative reporting. He was trying to intimidate a witness. Which are all powerful arguments. This judge doesn't.
And I just don't see how ever screaming, you guys shouldn't lie in court. You guys need to tell the truth. Can you intimidate a witness into telling the truth? I mean, maybe technically. I don't know.
I mean, they came in and testified to what they were always going to testify to. So,
Right.
That's like the proof's in the pudding with that. They all testified. And
I
they all
just don't-
testified.
I don't
to
think you
exactly
can
what they were going
demand-
to testify to.
But I just don't know that you can be demanding the truth and be told that you're harassing that you're intimidating.
I agree. I agree.
All right, let's see what Cosgrove's sorry ass has to stay back.
Is waived because they had the grand jury minutes at the time that they brought the last motion, including.
The Scanlon argument, it limited to the idea that they should have instructed.
Right.
Okay.
Right. The second point I want to make is the argument that they don't know what information came from Ms. Peters. I guess my response is, it doesn't matter. It doesn't matter that she has an animus against Mr. Kearney, that the two of them are oil and water. Doesn't matter if the Commonwealth got those videos.
Pause 1 second.
The Ripper, or whether the Commonwealth
Just
got
paused.
St. Teresa. The question is,
So he's like, oh, it doesn't matter that it came from Miss Peters or didn't. But what it does is the lawyers involved, maybe even the detectives involved, should have fucking realized that they were getting that they were getting manipulated information. Unless they went and watched the entire thing as well, then they don't realize that they're getting manipulated information. They don't even consider that as part of the possibilities. Like, look, this bitch might be taking shit out of context and giving us just like.
Wait, you think that the cops involved with this would give a shit about that?
Well, I guess
Like that defeats the entire purpose. The entire purpose was to shut him up. Like they don't give a fuck like what it looks
All right,
like.
so then not the cops, but the state should have given a shit.
Okay, you don't think the Commonwealth wanted to shut him up too? I mean, they had invested a huge amount of money in this case, like the taxpayers' money, and 2 trials, and what they got out of it was a DUI. So, I mean, they wanted to shut him up. I mean, that's the background of all this. Like that concept needs to be understood and acknowledged by any of these judges sitting on any of these cases. That's a reality. They were actively trying to shut him down from talking about this case publicly, period, because he was effective. He was effective in getting people through his petitioning activity, rallied up, riled up, ready to get out there with picketing signs, ready to get out there wearing pink on every single court date. Like they were trying to shut that all down, and I mean, if the Commonwealth of Massachusetts is fine with that, which is shocking considering it's one of the bastions of our country in terms of when we were being formed. A lot of shit happened in Boston. A lot of shit happened historically speaking, to where it's surprising to me that judges would be turning a blind eye to this kind of stuff, when they're trying to shut somebody down. I mean, look, we all know the Fourth Estate, as it used to be known in terms of journalism, for all intents and purposes, is dead, but that don't make it right.
Yeah.
I mean, you can hate Aidan all you want in terms of the way that he says shit, but in terms of what he was doing, you can't argue with it.
No.
You can't argue with it. We have to have freedom of the press. We have to have free speech in this country. It's the only thing that helps us keep the government accountable, aside from defense attorneys going in there and filing our motions to suppress, calling them on their bullshit when they violate people's rights. I mean, those two things, but for them, we're living in a fascist society. It's that simple, because there's no way to stop them if you don't have those two things happening. So I don't know. It's irritating.
Is the video evidence authentic? And it is.
All right, enough on that. Next issue. Do we have the third party here?
Yes, Your Honor.
Yes.
All right. From the defense, I didn't get a response or opposition. Is there a response or opposition?
No opposition.
So they're fine with releasing these matters?
Judge, we're, from our perspective, this is all out in the possession of the internet, if you will. And it seems like everybody has it and can look at it except Mr. Kearney. But that's another issue for another day.
Well, we return it. Did we not? That was the order that the Commonwealth asked me to do.
Okay, hold on.
Yes, Your Honor, but it's there's all sorts of.
Okay, just a sec.
Okay, whoever's on the video, need to shut down.
Oof,
Oof.
oof, squeaky.
And further, Your Honor, Mr. Kearney provided Attorney Diller with all these communications.
So this is not an issue. Because my intent, frankly, my first impression here is I want to protect Mr. Kearney's rights not to have these materials, investigatory materials released. But if you're okay with it, I'm not going
Well,
to.
Judge, I appreciate that, and if you're inclined to do that, I certainly would ask you to do it.
Well, that's why I asked you if you opposed it, and you said no. So,
But if that's your inclination, Your Honor, any layer of protection we appreciate. But unfortunately, this is out on the internet, number one. He's given it to Mr. Diller as a pro se, non-party deponent.
so what do you need from Mr. Diller? What do you need from me if you already have it?
I don't
Yeah.
know that I have it. I know that I just got a link from Mr. Kearney a couple days ago because I went into our case and also got a motion to compel, which was allowed. So I'm entitled to at least compare the two matters to see whether they are consistent and that it's comprehensive. I appreciate.
Why this before Judge got laid on me?
Who the fuck's this guy?
One of the civil lawyers.
Oh,
He's trying to get his fingers on some shit, and he's saying, "Why don't you talk to Judge? Bump it back, and we'll hear what Judgy says."
Okay.
Was before Judge
There.
Tells them to go to
see
Gilday.
whether they are consistent and that it's comprehensive. I appreciate.
Why this before Judge Gilday, not me?
It was before Judge Gilday and he issued an order. There's a separate issue, which is we've executed a protective order, and any of the materials that will be provided from this case to us will be protected. There's also been a Gilday order that there's no dissemination or discussion of any of the confidential information, so there will be no leaks of data into the world. And
No
this
leaks
case
of
will
data.
come to
Ugh,
judgment prior to.
it's
the
too
appeal
much.
case. So we'd ask that we get access to those materials. We know that they are the authentic materials, and we request we'll execute the protective order, as will the other parties who do not object in the O'Keefe matter. Will all execute the same confidentiality protective order, and will be used exclusively in that
For the
case.
record, let's get your name, sir.
Attorney Mark Diller on behalf of the O'Keefe family.
Okay. Any further, anybody want to be heard on this?
Yes. I don't have any objection to providing Mr. Diller with a copy of the same materials that I believe are already out there on the internet, ironically, have been released, not by Mr. Kearney personally, but through someone who was associated with him, as I understand it. The problem that I'm dealing with is
This judge question protected.
is essentially found on Exhibit B to the motion to intervene, which is the order from Judge Sisinski, which was entered in the Karen Reed case. That motion was brought by Mr. Bederow on behalf of Mr. Kearney, and Mr. Bederow, as I recall, wished to bring it with respect to both the Karen Reed case and with respect to this case. Judge Sisinski announced at the outset that he was only there to deal with the Karen Reed case, wasn't going to touch the Kearney case, but the language of the order prohibits all agents of the Commonwealth, which would seem to include me at the moment, Your Honor, from requires us to maintain the confidentiality, which is now essentially non-existent, not share, publish, disseminate, or otherwise disclose the data or any information concerning the data. So I may be partially to blame for this matter being before Your Honor this morning, because my position was, I'm happy to give it to you, but I don't want to get caught between an order on the criminal side telling me that I have to protect this information, not release it, not disclose it, and an order on the civil side saying, turn it over in response to the subpoena.
And this has already been produced by Mr. Kearney on his own.
That's my
correct.
understanding.
Yes, as a pro se, non-party deponent.
All right. I'll take that for class. Okay.
Thanks, Your Honor.
Pick 139, this was the issue of the items from the TNT. Anybody want to be heard on this?
Yes, I'd like to.
Okay. I allowed it provisionally, but issued an order saying it couldn't be disseminated.
Right. The only thing I would say, Your Honor, is reading paper 134, which was the impounded report from Mr. Bederow. It looks like some of the work has been completed, and there are two instances where he's looking for guidance from the court. That's the very last item, Apple iPhone A1549, and Apple iPhone on the next page, where he says the extraction attempts failed and he would need permission from an order to request an attempt by a law enforcement agency. I'm not sure how long it would take to accomplish those things. I haven't had an opportunity since, thanks to your honors allowing a motion. I've only had this now for a couple of days. I haven't had an opportunity to check with somebody with more sophistication than I in matters of electronics and extraction. Someone more sophisticated than I would probably be a 12-year-old that could stop on the street, but I don't really understand what this would involve and how long it would take and what the expense would be. So I'd like a little time to look into that. But with respect to what's already been done, and it seems to be that they have, for example, the next to last entry, Honorable Macy reviewed and marked item for privilege. Working on producing the potential privilege data with notations by Honorable Macy, which items are deemed privileged for defense production. This was dated March 25th of 2026. This tainting process has been very laborious, and I would really like to get the ball rolling on this, or rolling a little further before we are up against the trial.
How soon do you think, how long will it take you to get to formulate your position for further steps?
I don't think it will take me long at all, Your Honor, a week.
Mr. Bederow, Mr. Bradle, what have you heard on any of this?
Judge, I don't object to a week, you know, if council wants to.
You have the materials he has is released to you.
Yes,
The report.
yes.
Okay. So,
See, I wasn't even aware of that.
well, that was the order that I issued.
Oh, you mean this, but. Okay,
That was the order that I got, was to release that report.
right. But the text of the report says that they have the data, Macy's reviewed it or has reviewed some of it. I would like some indication to the tainting that would like to get it.
I don't know what exactly is in play here. Mr. Bradle,
Yes, Judge.
you work with Mr. Cosgrove.
Okay,
You guys need to file a further motion to assist this process to speed up. Just get it to me.
we would like
I'll
to
draft
receive it first.
something, show it to Mr. Bradle.
You guys can work.
We'd like to receive it first, though, Your Honor. I appreciate the Commonwealth reference this in their submission, that to the extent that there is a privilege notations in here, we'd like to see it first,
Absolutely.
evaluate it.
Understood, I get that.
Okay,
All right, so look, get a report back to me 2 weeks from today, all right? And if you need a further court order to move the ball forward, we'd like to do that. I assume you guys will come with some agreement on it, right?
Yeah, I really think it'll be.
Yes, sir. I propose to council that just like to have it for, let's say, a week prior to the
I'll give you
Commonwealth
2 weeks to
proceeding.
sort this out.
All right, appreciate it. Thank you.
I suspect you don't easily interfere with this.
I don't think so.
I understand you may be less than so. Okay, last issue, which is the issue for disclosure on the project. Did you folks have some discussion on this?
We did, Your Honor. We're almost there. And I think we need court guidance on one disparate issue.
It's very wide right now. Far too wide. I think I know where you can go.
I think we're not gonna make you go through the labor of looking at our stuff.
All right, tell you what. 2 weeks to give me a report on what you see on that. All right, if you guys can reach an agreement, that's fantastic. Whoa! All right, we're gonna close the Zoom now. That's it. Zoom is shut down.
Goodbye.
Wow.
I mean, Judge, the only issue we're disparate on is the scope of the protective order relative to what Mr. Kearney can be shown and not shown. And we were proposing that it would be just case-related materials from the Proctor extraction. We'd be entitled to show him, not provide copies, to show him case-related materials. And I think council has a little more of a specific issue. I think that's the only issue we're disparate on.
If you guys have an agreement, and you want to work it out, that's fantastic. If you still need more time to have this discussion, you want to come see me even by Zoom, do that. If you guys have, again, you guys reached an agreement, I'm not gonna stand in the way, in the way. If you need further clarification after discussion, okay, tell me.
I was just hoping to gently push the Commonwealth today to put their position out, which we discussed prior to this hearing, and perhaps Your Honor can make the ruling. I think it's a pretty straightforward thing.
Tell me what you think I should know, Mr. President.
Essentially, I have folded my tent, so to speak, and agreed to provide information to Mr. Bradel to the same degree that has been provided in other cases where there is Proctor discovered. And Mr. Bradel has agreed that essentially the same protective order will be issued, which essentially boils down to that the materials provided will be provided only for the use of counsel and may be shown to the client, but the client may not receive copies of those materials.
Is there any restriction on the use of those materials by the client? I think that's probably what we're
Yes.
circling
Yes.
around here.
Yes.
Babe, is your keyboard on?
That's
No.
my concern, and it seems to me that
Probably
to the
Grant.
extent that the information, there's really two potential pieces of information. One is case-specific information, anything Mr. Proctor may have said relating to the specific case and Mr. Kearney.
That's would almost be automatic.
Sure, I would have no problem with that being shown to Mr. Kearney. However, it seems to me the bias information which is, as I understand it, a pretty standard, it's really the same for all defendants. The stuff's going back, whatever, the comments that Mr. Proctor made about this person or that person that potentially could be used to impeach him if he is called as a witness and show bias, that have nothing to do with Mr. Kearney in particular.
That's a bridge we'll cross when we come.
I don't wish to be shown. I would like to be restricted from showing to Mr. Kearney because I don't think that counsel needs his input if we come to trial to present a statement that Mr. Proctor made 12 years ago about a woman or minority or whatever. And if the likelihood is it's only going to leak out into the internet to the extent it hasn't already, impossible embarrassment.
You can start cracking the seal on people who make silly comments, inappropriate comments, unacceptable comments. It's going to open up things that we just don't necessarily need to come down. We'll cross that bridge when we get to it, just a quick pause. Mr. Brady, what do you think the intent is right now?
This issue that the Commonwealth wants to sort of parse out is too vague to parse that out. I can't look at something and say,
I'll give you 2 weeks.
it makes it adverse to the client, Your Honor, to have to
I'll give
withhold it.
you 2 weeks to confirm. If you guys haven't come to an agreement by that, call Mr. Donnelly.
Okay.
Come in and see me. It's a 15-minute hearing. Should not take us long.
Thank you.
All right, so we've got 2 weeks on the issue of the contained team issue, and 2 weeks on this issue too.
Thank you, Your Honor. And then there's also a housekeeping issue relative to the dates, Your Honor, for trial and motions in May. I think we wanted to propose to the court. I think we hammered this out before you came out, which is that we wanted to propose Friday, December 4th for motions in limine, Monday, December 7th for trial and jury selection.
Figuring out when's going to be able to use decisions.
So I have another concern, Your Honor. I don't know that we need to resolve it today, but I want to put it on the court's radar, which is This is a Norfolk County case. Where is this trial going to be held?
Well, I'm here right now. Let's put it this way. Wherever it happens, it's going to be Norfolk County Juries. Okay? That should satisfy any constitutional concerns.
I think that logistically, Plymouth Superior Court would be an excellent location.
Logistics, where it happens, is going to be a discussion which I'm going to have with other folks who are involved here.
Is it fair to
I
say,
appreciate that. I just want to put it out.
is it fair to say, Judge, that you'll know maybe in September when the next rotation comes through?
We'll have well, I'm in this room until the end of December.
Oh, okay.
So I'm assigned to something else
So you're
until January of 2027. So the assumption is going to be with me, and the assumption is going to be in this room. But we're going to have to make arrangements because this is a Norfolk County case. It's entitled to Norfolk County jurors unless he waives. And that would be my intention wherever this happens.
I'm going to discuss that with Mr. Kearney,
That we try in front of the Norfolk County jurors.
whether we waive it.
Well, Commonwealth gets, I think, word on that as well. So,
I had one other issue that I wanted to raise with Mr. Bederow, and I don't need to ambush him, but I do want to bring it to the attention of the court. There has been, so far as I recall, and I don't think I've lost my memory to this extent yet, no motion to suppress with respect to the devices that were seized from Mr. Kearney pursuant to warrant. Some of them may not be visible, but we have at least the two cell phones which the search was conducted, and the fruits of that have been turned over to the defense. Defense has the motions. I don't want to get to a week before the day of the trial and be told that Your Honor needs to hear a motion to suppress.
but you're right into the cell phones you intend to use.
Oh, yes.
So we need to have a discussion about this.
Well, I'm sure we will have a discussion about it in this ability. I'm just concerned about,
There may be an eliminate issue, Judge. We don't see any suppression issue.
All right, so there's no motion to suppress, we'll deal with it as a motion to eliminate.
That's where we were going, Judge.
that's fine.
Here's what I'd suggest, folks. Somehow, the judiciary tells me I'm going to get a lot of motions to eliminate. So maybe we should go back another week on the motions.
I'm fine.
Or at least take it to November the 30th, which is Monday before. We'll bring in the afternoon to deal with that. That gives us a full week to get decisions out and adjustments to be made in your trial strategy.
Judge, can we go? Can I just confer 1 second?
You're conferring. Shut all the mics off, so we couldn't get any hot mics.
No hot mic.
Dave, quit screaming. Why are you in all caps, man? What are the gems? I don't get what the gems are. Do you know? It's probably because I set the live as vertical.
Your Honor, we would like to avoid the Thanksgiving week. We're wondering if we could move it back to, say, the 19th or the 20th of November for motions and eliminate.
That's a Thursday and Friday. The 18th of November, we do our afternoon list on Mondays and Wednesdays, so to the extent we can stick with that.
18th, what about that, okay? Yes, that's fine.
So, any other schedule issues?
maybe file those, so agree to file them like a week prior.
That's fine. Couple days is all I need.
So 11th, out of court filing, November 11th.
Fine by me. Okay, just one other matter. That's Veterans Day.
10th,
For what it's worth.
whatever the closest date to that is.
So it's what? Give me another day. For now.
10, 12,
12.
sorry, 12.
Okay, although the Zoom is now shut down, let me just send this message right now. The court is fine with Zoom. The court is perfectly happy to have the public observe and see the proceedings that are here today, and going forward to observe the electronically observe the proceedings. What the court is not going to tolerate is commentary over the court's audio about people's thoughts. Happened 3 times. 3 times is all I need. I'm going to reopen the Zoom for the next hearing. If it happens just once, I'm going to shut the Zoom off, and that will be it for Zoom going forward. This is not a participatory experience for anyone but the parties. The message I'm sure will get out to the various parties who like to listen and rebroadcast. Zoom is a privilege, not a right. You don't get to participate in the hearings. Okay, anything else we can do today?
Just a little bit of clarification, Judge, on the dates. So I want to see if I have this right. November 12th, out of court, motion to eliminate service. November 18th, motion to eliminate, and that's 2 p.m., Mr. Clerk?
2 p.m.
And then December 4th, is that still a date or are we off the calendar?
We're off. Unless you can see me.
December 7th, trial.
December 7th. And folks, we can be flexible. If you need to come back a second time, come back a second time. I'll make time for you when it needs to make time.
Thank you.
Okay,
And we may come back on the practical protective order in the next couple.
so the 2 outstanding matters, number 1, motion dismissed to decide. The other 2 issues, on the tape team and on the proctor discovery, if you need further guidance from the court, let me know. I'll give you 2 weeks to try to sort it out. If you need me to decide it, I'll be glad to decide. Anything else? Mr. Cosmo? Mr. Bederow, Mr. Brady?
Very good, Your Honor. Thank you.
All right, thank you very much for your arguments today.
Matters under advisement, the court set the following future court dates: November 18th, the final pretrial hearing at 2 p.m. with a trial, or 2 weeks later on December 7th at 9 a.m. All rise. Court stays in the recess. Thank you.
You going? All right. Well, so that was what we call in the business anticlimactic. So he didn't really give Bederow much of an opportunity to argue the motion. He had thoughts when he got on the bench this morning in terms of, we're going to have to look at the Dell case and we're going to have to look at the Shaquille O'Brien case, the 2 cases that he cited that, in his estimation, shut down the argument in terms of certain things that Mark brought forward with respect to the mega motion, in particular, a lot of things having to do with Kate Peter, how the Commonwealth got information, how they were being fed information, how they then turned around and presented the information to a grand jury. And it was a hot bench. It was a hot bench. Judge wasn't really giving Bederow the opportunity to argue orally what was in the motion. So it's pretty much going to stand on the papers, essentially. The judge was relying pretty heavily on Doolin's earlier 38-page or 39-page order. Look, you got to come into these things with a realistic view of motions to dismiss in criminal cases. They're very, very, very difficult to win. They just are. They're so rare that you know, when they do happen, it's shocking and stunning. You know, they had done yeoman's work to get multiple counts dismissed early on through Doolin, and you know the remaining counts. It's going to be as simple as this. I mean, Aidan's going to trial on him. You know, so once that order comes down, I can't see a world in which this judge is dismissing anything based on this hearing. If I'm wrong, great. But the reality is that Bradel and Bederow understand how this thing works. They're not noobs. You know, they know that this is a long shot going in. You know, despite the strength of the motion itself, you know, they made the record. And if down the road Aidan's convicted, then, you know, they've got appellate issues that they could bring forth. So they did that. Yeah, Allie is in our daughter's room because our basement flooded. So, and we haven't gotten the flooring in. So it's not optimal. And she didn't want to wake our 20-year-old up. I would have rousted her right out of bed, picked her up, fireman carry style, carried her into the spare bedroom, dropped her in there. But, you know, Allie's not doing that. So, yeah, that was, like I said, pretty anticlimactic. We didn't hear much argument. And, you know, the other things that came about in terms of scheduling, you know, if I'm Bradel and Bederow at this point, I'm really starting on the motion and eliminate work to try to figure out what's going to be allowable at trial in terms of evidence. And that's going to have to be litigated going into, you know, heading into the trial. Like we've got to figure out what is going to be admissible and what's not. You know, the reality is that the defense here is going to have to be able to lay out the background of what was going on. You know, I mean, they've got to be able to argue that the Commonwealth has weaponized a statute to silence a reporter. And the only way that you can do that in front of a jury is you've got to be able to get into the background. So those are going to be things that are going to be hard fought, I'm sure, you know, and the judge is probably going to give very short leashes on what kind of background he's going to allow in at trial. But I mean, it's part of the story, you know, it's part of the narrative of the case. And I don't see any way in which, you know, the judge is going to avoid being able to have any of this background come in, because it's the impetus of the charges, you know.
Babe, can you do me a favor? Can you go back to the beginning? Because there was a couple things the judge said, all right, that's new. And I want to revisit those.
Let's see.
It seemed like there was some things that he was agreeing or not either A, waived, or B, already considered.
All right, let me.
I almost forgot I got a hearing at 1:30.
All right. Let me see. I don't know where in the beginning, like how far in the beginning.
Like, just go to the very, very beginning.
Okay. All right, I'll share it. She's still sleeping?
Yes.
Wow.
She went to bed late.
All right, let me see. Yeah, I don't know how Melanie made it bigger to get rid of the chat on the side panel there, but I don't know. Okay. So this is right in the beginning.
Retelling the same ground over and over and over.
13.
Waivers. Drafted a 36 or 37 page a decision, which is an exceptionally fulsome decision from the court, in which we found probable cause for the majority of the indictments, but dismissed all of them, including the one that seems to be at the heart of a number of these motions, that is to say, against Mr. Proctor. So the first issue is this: under Rule 13, under Commonwealth versus Del Santos, which I'm sure you've reviewed, which is 492 Mass 242, 2023 case. If the matter was not raised, it's considered waived. So tell me why. I understand the issues with Ms. Peters may have been disclosed post that hearing, at least to some extent. Tell me why the other issues aren't waived under Del Santos and Rule 13.
Okay. Was there another issue you wanted to focus on?
No, that's to start. Then we'll get to the substance of it.
Thank you, Your Honor. Judge, it is true that many of these issues existed in grand jury transcript and motions that were ruled upon by Judge Diller. That is correct. And Rule 13 does state what it states, but there is case law which also states that the court does have the power to reconsider or reevaluate issues which were not brought to the court's attention. Now, in this particular case, there's no question that issues that related to the wiretapping, the uncharged wiretapping, for example, could have been raised. As the issues related to some of the videos in this case, the name changes, the court should be aware that for whatever reason, that snuck by everybody, including Judge Doolin, including Mr. Cosgrove and some of his filings. And as soon as that was picked up, that is something that we put into writing and addressed right away. The reality is the grand jury in this case was not proper. I mean, I think, and I'll get to that in a minute after answering Your Honor's question about the waiver issue, but in terms of the form over substance.
It's not really form over substance. It's substantive. Rule 13 is substantive. Del Santo is substantive. And there's a reason for that. And the Commonwealth in their opposition has pointed it out. It's because you can't keep retelling the same ground over and over and over. It's not going to get move forward. So it's not just form over substance. So you got to give me a little bit more than that.
Well, Haskell permits it, Judge.
It does at the court's discretion.
Right.
But you got to have a reason.
Absolutely, there is discretion of the court to ultimately decide what should be done and what shouldn't. But where the court sees prejudice, the court respectfully should act. Now, again, with the videos that were mislabeled, the Commonwealth shouldn't benefit from what is clearly deceptive conduct in terms of renaming items that, again, nobody saw. Judge Doolin himself referred to the names by their improper name during his ruling.
Which presumes that Judge Dillon was aware of those names and didn't find them to be of any substance because he watched the actual videos.
I don't know of the actual videos that were presented to the grand jury, Your Honor, were
But did he know that wasn't the actual title?
our
Question.
video, which were not grand jury exhibits. So respectfully, there's no way that Judge Doolin could have watched those videos because Mr. Mello
And you watch the clips, no doubt.
yes, but the clips are tiny segments of larger videos that, again, when we get to the real meat of what I want to discuss with the court, would show the full context on the critical issue in this case, which is only one, and that's Mr. Kearney's intent. That's the only issue that was really before the grand jury, and none of that was seen in Judge Doolin's opinion because none of that was before.
Because it wasn't raised.
Well, it wasn't raised, but it wasn't known by anyone. Now, again, could it have been? Yes, but the court has the discretion.
But it was known because Judge Dillon referred to it by the titles that you think are inflammatory.
Yes, those are the names that he was provided by the Commonwealth that were changed. Those were the improper names. Names that the Commonwealth knew in advance were not the proper names and were changed. And ultimately, Your Honor, as a matter of discretion, there's no prejudice to the Commonwealth here by having this. I suspect this argument, which is a fair argument to make, is their primary argument because they don't want to talk about what actually occurred in the grand jury. And the fact of the matter is, everybody sees it, everybody knows what it is, and it ought to be addressed. If there's no prejudice to the Commonwealth, the court should hear it. No indictment should be tolerated when it is rife with misleading evidence, distorted evidence, statements of prosecutors and police witnesses saying, in my opinion, it was this man's intent to commit witness intimidation. That's outrageous behavior in front of a grand jury. And when you get down to brass tacks in this case, that's all that this is about. They misled the grand jury on the only issue that matters, which is whether Mr. Kearney's intent was to commit witness intimidation or not. The conduct at issue is open and shut. It's the videos, not the videos that were submitted into the grand jury. Those are tiny snippets. The conduct and the context of Mr. Kearney's intent are contained in the actual videos. And what you have at this point, it's very similar to Odell itself. In essence, you have prosecutors cherry picking 30 seconds they like out of a 2-hour video and saying this proves his intent was to intimidate witnesses, but not letting the grand jury have access to the other 2 hours, which show him saying, I want to bring awareness to a miscarriage of justice involving Karen Reed. I'm petitioning the government to address that. I believe that these police officers are corrupt. We're doing this to bring justice for these people. The grand jury had a right to that. And the best example of this, Your Honor, to get a full picture of what you're dealing with is all of the picketing counts in this case are from this so-called rolling rally. That entire video, the whole rally was recorded, video recorded by Mr. Kearney, literally the crime, if you will. They didn't introduce that video, but what they did do was admit 58 seconds of the rolling rally, which the honest name of that video on YouTube was Canton, the rolling rally, Justice for Karen Reed and John O'Keefe. They took 58 seconds of that video. They introduced it as the title of that video is Don't Feel Sorry for the O'Keefes. That's not evidence, but if you look at the grand jury testimony and the transcript, the way Mello and Tully did this is Tully said, the name of the video is Don't Feel Sorry for the O'Keefes. It's contained in a folder literally titled Intent. Literally. And he did that approximately 30 times throughout this proceeding. Told the grand jury, this is proof of his intent.
I think it's after this whole little colloquy. I think it's coming up.
They played 30 to 50 seconds of this video where he literally says, don't feel bad for the O'Keefes, but yet don't present the video of the crime. Why? What prosecutor?
But their allegation is that he's the crime.
Your Honor, again, it goes to Odell, literally. They can believe anything they want. They can allege anything they want.
But they're not alleging that the rest of the rally was intimidation. They're alleging those clips.
Of course. Right, but Your Honor, when they present it to the grand jury, it's tantamount to what happened in Odell with the police report, where we decide we like sentence 1 because we think it proves his intent, but we don't like sentences 2, 3, 4, and 5. So we're just going to keep that from the grand jury. In Odell, that was deemed to have impaired the integrity of.
The police report and the video are very different things. We often encounter situations at the grand jury where they have hours and hours of videotape, but they only play certain clips.
But they didn't tell the grand jury it's available for you. The point is, they told the grand jury the name of the video is. Jury influence is another one, which was actually titled Protesting Michael Morrissey. Big difference. A video that was 5 days after DA Morrissey made a statement to the press, which was improper. He gives a 2-hour video and says, I'm trying to bring awareness, trying to do this and do that. And this is in August of 2023, well before a trial. And says, absolutely, I want to influence the public and the jury pool. And they take that little snippet. They may have a theory that enables them to say, we believe that's proof of his intent. That's fine. What's not permissible, though, is to rig it in the following way, to say, literally, Your Honor, I can read to you literal, there's a literal question and answer, which is very important. For example, on December 19th, question from Mello to Tully, before he plays all of these videos, which are misnamed, cherry-picked, do you have any knowledge of incidents which you feel are intimidating of a witness with respect to any particular witness? I do. Question, those are on video. Answer, they are. Play those for the grand jury. So now we've just told the grand jury, I think his intent was to intimidate witnesses. Then what Tully does again and again through direct intentional questioning of Mello, it's not volunteer, is to say that these videos are named inaccurately, and they're in the memo. You've seen them, page 62 and 63 of the motion, all the times that they did this. They play the snippet, and then when it's over, they tell, or before they do it, they tell the grand jury, these are from a folder marked intent. He didn't do that.
So, you have to give the grand jury some credit.
I think it's after this
The grand jury
comment.
understands that a defendant is not going to create a folder which says intent. They had to know the prosecution created that.
All right, so pause it real quick, babe.
Right, but give the
Because I know you want, before we even go further to try and find the part I'm looking for, just speak to that because it's insane.
It's insane. I mean, what else do you have to say? It's like the judge is giving way too much credit to the ham sandwich committee. Like it's that simple. You know,
And
like
a lot of the chat was like commenting the same way.
I mean,
Wow.
how does the judge think that the grand jury is going to know that? Like the grand, if you're summoned to be a grand juror, it's like once in a lifetime type shit. You go in there, they don't give you an instruction booklet. They don't tell you what you can and can't assume. That's not how this thing works. You know, so whatever the government's going to put in front of them, I mean, Bederow's argument is strong, right? I mean, in the way that they're framing it, the way that they're twisting it, and this judge seemingly not having a problem with the way that they presented the case to the grand jury is scary. You know, I mean, essentially, this judge is saying, yeah, you know, it's the prosecutors. You know, they're gonna tell their story. The jury knows. I mean, the defendant's not there. The defense attorney's not there. You know, clearly they know it's the prosecution's theory. I mean,
Right,
we've
no one
spent
thinks the
3
defendant's that
years.
stupid. No one thinks the defendant's that stupid. That's what he's saying.
I know.
Jurors don't think a defendant's that stupid.
We've spent 3 years trying to explain to people that, you know, the law is complicated. Being a juror is I mean, people don't even understand the concept of beyond a reasonable doubt. Like that is one thing that I'm incredibly confident on, that a vast majority of jurors have no idea what that means.
I think you're more to your point is like not understanding the lack of a burden to get to that point. Like that they don't consider what the defense did or didn't do in even getting to that point. But I agree with what you're saying as well. But like to compound it is they're always saying, well, but the defense didn't prove this, or in their minds, you know, the defense didn't present this and the defense didn't challenge this.
Well, it's like that is along the same lines of when prosecutors stand in open court and saying that the state has a right to a fair trial. No, they don't. They unequivocally do not have the right to a fair trial. That is a right that sits exclusively with the citizens, because that's who the Constitution protects, not the state. Like they can't compel a person, a defendant, to testify. You know, all they can ask for is a trial that is run properly. That's it. Beyond that, they don't have a right to a fair trial. And when they do that, when they say that kind of a thing in front of a juror, or, you know, in public in a pretrial hearing, people misconstrue it, and people think that it is a right that's shared with the government and the citizens, and it's not. And it's going to exactly what you're saying. It's how things are framed, you know, and people simply, if they don't know, they don't know, you know, and a vast majority of Americans just don't know, unless they watch our channel, then they know, because we're chirping about it constantly. Yeah, I mean, look, this thing, it's not going anywhere.
But I think right after this, there's something that he says. I'll give you that. I think I could be wrong.
All right.
Grand juries some credit. They understand that.
Your Honor.
No, they don't.
The point is, respectfully, when a police officer tells the grand jury, in my opinion, this man's intent was this. I have a folder with proof of his intent. It came from that folder. I'm going to tell you a false name of the video that I renamed, or some third party working with him renamed, whichever the case may be. And then you don't tell the grand jury that this was renamed by us, put in this folder by us. I'm playing you 30 seconds, but I'm not going to give you the rest of the video. And I would refer the court, this case is cited in the memo of law that went with the motion, the appeals court case, not the SJC, the lower appeals court, where they...
See, to me, the bigger argument is less the intent folder, and it's more the renaming of what the lives were. Because they're literally using whatever title that Aidan may have used for a particular live, and they've changed. They're not using what he wrote. They've changed it to something else
to mirror what they
have
think
his words.
Intent is.
Right, have his words prove intent.
Right,
but they're not his words. Like that. That's the part where, if I'm Bederow, I would have just dug into that. I would have said, forget the intent folder thing. All right. Clearly, I'm not moving you on that, because that's where the judge is like, all right, well, I mean, clearly, they're not going to think the defendant created an intent folder. Like, that would be insane. Like, no, but in terms of them twisting the words and changing what they were called in order to move the needle on what Aidan's intent may have been, is completely nefarious.
It's crazy. And that's what Bederow does, like what you said. He does lean into that. He's doing it as best as he can in the amount of time he's given him to speak.
Yeah. He's shutting them down pretty hard.
Cherry picked a portion of a statement of a defendant, left the full flash drive in front of the grand jury, but never alerted them to the contents of it. And in that case, the appeals court found it impaired the integrity by hiding the ball. Here,
you're going to go there, Mr. Bederow. If you're going to go there, then you got to talk to me about Shaquille Brown, which is the SJC, in which the prosecutor dumped in at least 100 pages of prison records, in which the prosecutor dropped in telephone logs, all of which had never been looked at or never been read. And the SJC said, well, it wasn't so good, but that's okay because it didn't change the analysis of the evidence, which takes us back. And this is the difficulty.
Yes, sir.
This is the difficulty that you have. See, this is why Del Santos does matter. It is substantive. Okay.
Maybe I made that up.
13 is substantive because you already had a very thoughtful, all right, a bulwark, if you will, from a judge, all right, a very thoughtful judge who examined in detail the entirety of the grand jury, found it to be free from prejudice, and more importantly, found that the evidence was substantial enough to issue an indictment. So that brings us back to the court's analysis in Shaquille Brown, which I'll give you the side if you like.
I have
490.
He's like, I reviewed that.
171, and I'm very familiar with that case. All right. In that case, the court finds clearly they shouldn't have done any of those things, but finds it didn't impair the integrity of the grand jury, which does, and this is why Del Santo is substantive. Because Judge Doolin's already made that determination. So you got to get around that.
I'm happy to, Your Honor. The difference with Shaquille Brown and Judge Doolin's decision and why it matters here is context is everything in terms of his intent.
That's what you're saying.
But in Brown, they're trying to show joint venture, and they dumped in prison records that they haven't even read.
Judge, I'm bringing it to this case, okay?
But this is the SJC telling this.
I understand that, but the facts here matter, and the context matters, and just because the prosecution has, a one-sentence explanation of what they say and the grand jury ultimately determined was proof of intent after they were told what his intent was by the prosecutor, by all the reasons that we spoke about earlier. Context is everything. If there is a long statement that was talking about protesting and bringing awareness and making jokes and all kinds of things, and there's a comment in there that I like that comment, just give the grand jury the whole thing. The role of the grand jury is fact finder. The problem in this case is that Mello and Tully decided to be prosecutor, detective, and fact finder.
Grand jury's not really fact finder. Grand jury's more of a gatekeeper. But go on.
But they have to find,
More of a what?
respectfully, they're not. They have to find the facts to support an indictment.
He called him a gatekeeper, which is incorrect.
Yeah.
That's not
I mean,
right.
a gatekeeper to charges, but still they're supposed to be investigating.
Yeah, they're
I
the
mean,
fact finder. They have to
fact
find that
finder.
there was enough to bind it over, to indict. I mean, what is this judge talking about? I mean, look, he came into this, he's already ruled on this clearly. I mean, talk about context clues, because the problem here is what I was just saying, and it's never going to go away. He's talking about De Los Santos and Shaquille Brown, where they left, 100 pages of something and, some kind of flash drive or whatever. And he's like, oh, well, the, Supreme Judicial Court said that was bad. You shouldn't do that. However,
Right, but that's why
it doesn't
Bederow
change
keeps trying to bring it back to context. He was like, yeah, but here they misled
Right.
them about the context. It's different than even
context is
leading it out.
everything here.
Right.
Like, you got to kind of look at it in like the same way that you'd look at a Frank's hearing, wherein, that you have the state come in and it's usually a cop and they're talking to a judge and they're saying, okay, this is what all the probable cause that we have is. All right. And then they lie about some of it, or they reframe it, or they cherry pick, or they do all the things that they did here. And the judge can say, okay, well, look, I'm going to take all that stuff out. I think that you've met your burden, and I'm not going to look at any of that. But what they do have, what you haven't alleged that they came in and lied about, or were untruthful about, or omitted, is sufficient enough to meet probable cause. So I'm still going to bind it over. He seems to be kind of making the same argument in terms of whatever
Right,
that
they didn't
Shaquille Brown
the evidence anyway.
But it does.
It
Like,
sure
that's the
does.
difference. Like, you can't change the word. If you're going to say that the intent, which is so critical in this case, like when they get to trial, the intent is everything here. Like, that is the biggest hurdle that the Commonwealth has to cross, has to jump over in order to get a conviction on this case, is Aidan's intent. Because you always have to show intent in the case, and you have to prove each and every element of every statute that he's charged under. And the intent has to be proven here. It has to be. And so
Right.
when they went into a grand jury and they said, okay, these are the words that he posted, okay, along with the live, and or at least gave the grand jury the impression that those were the words of Aidan Kearney, and they weren't. And then they're like, okay, well, I mean, the dude's like sitting here, pretty specifically saying he's trying to intimidate witnesses. Like, you can't have a grand jury going on that information. It's
Right.
just, it's a complete, like Andy Copsa keeps calling it, a misdirection of the law. It's worse than that. It's worse than a misdirection. It's a lie. It's an untruth that's being presented to the grand jury. And if you have judges in here that are sitting there and they're okay with it, that's a problem, because it sets a precedent that you can
Right.
do this.
Right, and the point that Bederow keeps making, that just like the judge isn't willing to accept. I mean, it's really all three things put together. You're starting with the concept, whether they think he named it or the state named it. This is our big evidence of intent. So here's all the things that prove intent. You're starting off by telling the jury, this is what proves intent. And then she's got an alarm going off anyway, so I feel
boy.
safe at this point.
Oh boy.
she still has her eyes closed. But then they're like, they play just a snippet without any context around it, and then they try to give the context by the title of the fucking thing. And
Right.
that's what, well, like, that's why he keeps trying to like explain this to the judge, and the judge is just focusing on like one little point, but all three of those things together create the untruth that you just explained. I mean, it really does. And maybe I was wrong. I thought there was something right around here, and I think that I thought he said, I'll give you that is new or something different, but maybe I misheard earlier. But I think it was still helpful to rewatch that point, kind of just focus in on
Do you
where
want
the
me
judge.
to play any more of this?
I don't know. I could have been wrong about what I thought was said. And there was another point I wanted to ask you, babe, and uh, I'm whispering. Hold on. I gotta let her out of her own room.
All right, I'll keep playing this till she comes back.
And in this case, they literally did.
The grand jury is more of a gatekeeper. But go on.
But they have to, judge, respectfully, they're not. They have to find the facts to support an indictment. And in this case, they literally did, but they were misled, and context matters. A grand jury is entitled not to everything in the world. It's clearly not a trial jury. We all understand that. But when you do it, you have to do it fairly. And they put their finger on the scales with evidence of his intent in terms of what they told the grand jury, what file it was in, the length of the video, the full context of the video, the uncharged crimes. Judge, the last piece of evidence in this case that they put in the grand jury was an uncharged crime of, again, the rolling rally video, which they didn't see fit to give the grand jury, which makes no sense. If anyone's prosecuted these cases and put in cases in the grand jury, that makes no sense. That's the crime. Give it to them. But what they did was they tried to suggest that he was harassing and intimidating the O'Keefe. So we're not even charged victims in this case. That's how they finished the grand jury. That is clearly a design to prejudice, to smear. They put in evidence of an uncharged wiretapping and read the statute that said this is punishable by 5 years and never gave a curative instruction, never withdrew that charge. De Los Santos or not, Your Honor, the question is, at what point do we not avert our eyes to what they did? They need to do it fairly.
But the judge has already looked at that.
But he didn't see that, Judge. If you look at Judge Doolin's decision, none of that is addressed because he, like everyone else, was misled. Moreover, Judge, I am focused on the grand jury. I'm going to answer the questions that obviously you're focused on. There was a second component to the motion for extreme government misconduct, and there's no reason why.
Well, I'll listen to you on the Peters stuff. I mean, I think if Peters wasn't known to you, I think that's fair to discuss.
Well, it wasn't. I mean, the whole point, but before I get to the merits of that motion would have been made anyway. So that, I mean, because we can't make a motion based on evidence of which we're unaware, obviously. And at that point, if you're making a motion to dismiss for extreme government misconduct, there's no reason why the court should not consider as a facet of the misconduct that occurred in this case what occurred in the grand jury before. Now, as far as the Peters stuff, which I don't want to beat to death, and most of it is in the papers, the point is all of that evidence should have been disclosed in early 2024, which was we're closing the deadline for discovery. That material didn't come anywhere near that timeline. It came in July of 2025 after numerous very specific Brady demands and Discovery Rule 14 demands. They could not have been more specific.
So let me understand, what is the basis that you're asking me to dismiss? Is it for the discovery violations or for the substantive violations?
Well, it's for everything. On the second component of the motion, the indictments ought to be dismissed based on the impairment of the integrity of the grand jury proceeding, full stop. As far as the second component, based upon the lack of discovery, that prejudiced us from filing a full-throated motion the first time. The court should consider that in even hearing the grand jury component of it. But in any event, if the court is wondering why discovery was ordered to be completed in early 2024, and all these demands were made before, during, and after that time period, and stuff that is responsive is showing up in July of 2025 that we turn out to learn was in the possession of every single prosecutor on these cases in December of 2024, which is before the motion was filed in front of Judge Doolin. What is going on?
I consider these to be two separate categories. That's why I started with the issue of Peter's maybe something which is outside the Rule 13 of the De Los Santos analysis. Just want to give you an open field to discuss that.
Okay. Excuse me, Judge. The evidence that exists or no longer exists from the third party that the court mentioned is extremely prejudicial to the defense. There is a strong argument that could be put forth if there were to be a trial in this case that this investigation was biased, it was shoddy, and that involves any number of things, one of which includes, from our perspective, which is a shockingly close relationship between a private civilian, Peter, who you mentioned, who has a hatred of Mr. Kearney that is beyond adjectives that I could even provide this court with. Not only that, this is a witness who has falsified evidence against him. Literally, this is not in dispute, it's in the motion, has forged court filings to try to screw him in part of their fighting during their lives, has attacked witnesses for the Commonwealth, Alberts, and tried to get him to say bad things about them when she, in fact, defamed them. And this person was basically holding Mr. Mello's hand. These are the messages that we got, amongst other things, telling him what to do. And when we got that affidavit from Tully, oh, well, I didn't open or click on any of these links. That's a problem for one reason, because they were in their possession, custody, and control, and ought to have been turned over. And what was contained, we don't know. But there has to be under Neal a reasonable basis to believe there might be something useful. And the reasonable basis you have is that the person who provided it to Tully that he claims he never opened has committed forgery, fraud, deception, and crimes against him. She's a dishonest person who is working hand in hand with the prosecutors in this case. Now, Tully says, I never opened it, and now the links are gone, and we were told in filings, it's been dismissed, it's been deleted by a third party, which presumably is Peter, and what are we supposed to do in now finding the evidence to support that defense? Just assume it's nothing helpful? Why would we assume that when this woman is bent on destroying him and commits fraud? What's that?
Isn't the shoddy work that he never opened?
That's amongst other things, but I said to you, Tully said that. That's not what Mello did. The emails that we got too late in the process literally show Mello and Peter talking, and he's asking her help. How do I open this? And Mello says, gee, thanks. He literally opened it. Opened what? Where is it? Tully says, I never opened it. It's deleted. Mello, very noticeably, never submitted in all the time the prosecution had to respond to the motion, and if the court remembers, they got many graces and deadline extensions to file, never submitted a sworn statement explaining any of this. What we got instead was a hearsay statement where Mr. Cosgrove, and I say this with due respect to Mr. Cosgrove, was essentially cosplaying as Mello, saying, this is what it would be. That's not evidence in response. What was required is something from Mello under oath, and we've never gotten that. And that's very important too, Your Honor. One of the things that we asked for in the motion is, as an alternative, a hearing. Okay? If this was intentional, the court should factor that in. Now, how can the court make a finding whether this was intentional or not without hearing from Mello, Tully, Peter, anyone else who may or may not be involved in this?
Does this affect the grand jury presentation?
Well, Peter,
I just want to see the argument. I'm not
As far as the grand jury goes, it's either Tully or Peter who renamed these files. Now, Tully knew the full name of the files.
But according to Tony, he doesn't own it. So I'm just trying to, you may have a separate argument. I'm not saying you don't. Okay, as to what the relationship between Mello and Peter was or was not. I'm just trying to make sure I understand your argument. Is this part of the Odell or is this some separate motion?
Well, on some level, it's a hybrid. I mean, there's clearly the Odell component.
I gotta understand what that hybrid is,
Right.
Council.
No,
You give me kind of a mishmash here with all sorts of stuff in it, and I'm trying to sort it out.
Judge, there's a standalone Odell motion, clearly, about impairing the integrity of grand jury proceedings. We also filed,
But how does go on, I'm listening.
there is a second motion to dismiss for extreme and egregious government misconduct based upon,
Each meeting was a separate motion to dismiss based on what you filed.
no, Judge, it's a second point.
This is the problem, what you filed. We'll discuss that already. I can't discern that there's a second motion to dismiss. It looks like a big Odell.
Judge, we don't know what missing evidence we didn't get. And the argument that was put forth in Mr. Cosgrove's response to this was that if you don't know, then there's no obligation for us to turn it over because there's no reasonable possibility to conclude that it would be favorable to you. And the point is, when it's evidence that was deleted, that was reviewed by Mello, Tully claims he didn't, and it comes from a source who hates him and commits acts of fraud and forgery against him, there's a reasonable basis to believe that something wasn't right in that evidence. We don't know. And this woman was assisting these people back right before literally days before the grand jury, explaining to Mello how to use the evidence. What is that evidence? She sent a folder titled Intent. That may we don't know, but that may very well be the clips, the change names. She'll probably deny it. She'll go online and deny it and scream and yell about it. Tully says, I never looked at it. Mello is unheard of. He just disappeared in the wind. There's no sworn statement from him. These people at a minimum should be called in, take oaths, and let's get to the bottom of it.
Let me get a better motion than like that. Mr. Cosgrove, what do you have to tell me?
Want me to just go through it? It's right.
Sure, we just think this is important.
Okay. First, whenever I hear counsel use the word cherry picked, what that means to me is the Commonwealth picked relevant evidence to support the charges it was looking for. I don't have any real answer. I don't deny that that was what, in this case, Mr. Kearney said and did and put on the air.
Why not give them the whole video?
I'm sorry.
Why not give them the whole video? Say, go to Mr. Bederow's point. Why not give them the whole video to watch and play them select so this is often the case?
I don't know what the reasoning was at the time, Your Honor, but if you look at the chart that Mr. Bederow includes in his motions, his affidavit rather, it runs on for about 3 pages. There's lots of videos. They tend to go about 2.5 hours each. If we give them the whole video, there is lots of other material in there that language used by Mr. Kearney, whatever, they could be construed as prejudicial. I'm sure Your Honor has already heard about reference to the O'Keefes, and the Commonwealth introduced this, and they didn't indict him with respect to intimidation of the O'Keefes, and this was entirely inappropriate, et cetera, et cetera. I'm sure if Mr. Mello had put in 25 whole videos, we'd be getting an argument that all kinds of prejudicial material was put in, and that the Commonwealth should have simply chosen what was relevant to the indictments. I have to say, where's the beef? I keep hearing about stuff being taken out of context. If only there was the context, if only the whole thing had been shown, the defense has read my response, it said, Your Honor, and one of the things I said was, where's the submission to the court? These are the things that if only the grand jury had viewed them, as Your Honor is now capable of viewing them because we have submitted them, and certainly Mr. Kearney has access to his own video, he would have put things in a completely different light, and here's why. You don't have any of that.
All right, babe, I think that
There may be some things in the entire videos.
What?
I think what I was looking for as far as what the judge was saying wasn't what I thought he said, apparently.
Okay. So pull it. All right.
What was this all about? Like the whole, why are they presenting evidence from like Suffolk County and Norfolk County? Like, why were they even doing that?
What do you mean in the grand jury?
Yeah.
I mean, what are you asking me for? I don't know. I mean, they were pulling anything that they could to try to.
Yeah. Seems like that was all just to taint the grand jury.
Yeah, I don't I don't know. I mean, look, at the end of the day, again, motions to dismiss are very, very difficult to prevail on. They just are, but like I was saying, whether or not I don't know if the judge is truly not understanding the concept of the context and the importance of it in the background. I mean, Bederow made an excellent record here in terms of his argument. Like, it was clear to me what the argument was, and again, you're coming in with a judge who appears to have made a decision before he even took the bench in terms of, I'm not dismissing any of these, he's calling Doolin's order, he's like a bulwark. He's like, your mic is weird. It's doing something. You sound like you're underwater. Huh?
I don't have I'm not using the mic.
Why?
All right. I gotta fix the headphones.
No, that's all right. So yeah, I think that ultimately, like I was saying, you were off, but I mean, they have to shift gears at some point here as trial is looming. They got to start arguing about how much of this is going to be able to come in at trial in terms of evidence that the defense is going to be able to put on to give an actual jury the context of what was happening in the world. Because you can't try this case without having that context.
And Cosgrove's like, well, he can have multiple intents, and he can also have the intent to intimidate. But I think you can also have the intent to get the truth out, the intent to expose corruption, the intent to bring awareness that has the ramification of, if you accept what he's saying as true, making the perpetrators fucking feel intimidated. I mean, it's just like to me, the only way that you can even accept this as intimidation, right, is if you disbelieve the possibility that these people were involved in the crime, involved in the cover-up, lying, deceiving, all of those things. Because I just don't see how a jury's ever going to say you can intimidate somebody into telling the truth in this manner. Sure, you can threaten, if you don't tell the truth, I'm going to bash your knees in, and then someone who wants to lie feels intimidated into telling the truth. But to say that your public statements, your cries for the public to be aware, your cries for action are intimidating someone into telling the truth, assuming what he's saying is the truth, I just don't see how a jury is going to get there.
Yeah, I mean, it depends on
how it gets here.
Well, that's how, that's what you got to deal with. It did,
right.
And it's on the precipice of trial. So, it survived multiple attacks. Now, obviously, I'm assuming which we all knows, we know what assuming can do. Turn an ass into me and you in
No,
terms of what this judge is going to do. It looks and smells like a denial. Like I'm not going to be at all surprised that this is denied and this moves on. But Bradel and Bederow are long on the tooth in terms of practicing law. This isn't their first rodeos. They know exactly how rare it is to get a dismissal. Pre-trial, especially on something like this. It's like everything in the system is built towards not getting to the truth, but towards getting convictions and then protecting those convictions once they've been had. So, and nothing's ever going to change with that unless we get judges on the bench that are willing to call the government on their bullshit, and this judge doesn't appear to be that guy to me. It's like you want to see a judge, any judge, to get incredibly upset about something that's right in front of them that is clearly slippery and shitty and
Right,
shady.
and he pushed back when Bederow tried to say this is form over substance, which it is. When he's talking about potential waiver or potential the judges considered all of this, but Bederow's saying, but he didn't consider this part of it and he didn't consider that part of it. And then the judge is pushing back that that's not form over substance. It is.
It is. It's still,
You're not looking, like Bob said, you're not looking at what's right in front of you because you're saying somebody else already did.
Right.
And I'm going to ignore.
I don't need to get to it.
Right. And I'm going to ignore the fact that you're saying more things that this judge didn't get the opportunity to consider because he did a damn good job at what he did consider. So the fact that he didn't have all this other information, not form over substance.
Yeah, I don't, and this isn't just a Massachusetts thing. This is every judge everywhere.
I mean, this judge seems like he's, he stayed on top of the law and he's considering the law. I mean, I don't think he's being an outright. I mean, that's what all judges do.
Right.
They find the stuff that works for them and they take sometimes the easy way out. But I don't think it means, is this the judge that's actually presiding over the trial?
Yeah. Yeah, he's the guy. So yeah, I don't know. I mean, it's frustrating when you go into a courtroom like that. Like, Mark was thinking about this thing all night, like leading into today. And, he gets in there and you're going through your arguments in your head and you never know how it's going to go when you get in front of a judge. You never know.
Especially that you're not going to get to talk at all about what you wanted to. He didn't really get to talk about the substance.
Right. I mean, he got into it a little bit, but he didn't get into it at length in the way that he would have. Like, I mean, in his mind, the perfect argument would have been, I'm going to get to lay this all out for this judge, and he's going to listen intently to what I'm saying. He's going to get it. He's going to understand what exactly happened here, because essentially what he's trying to do is reframe what happened in that grand jury by showing that the Commonwealth framed it in such a way that wasn't truthful.
Yeah,
the most important aspect of the entire things that they have to prove to meet that burden is intent here. And they went about getting an indictment on this case in an untruthful way by using I don't so much care about the intent folder bullshit. Like I get what Bederow's point is. It goes to the grander scheme, but when they change the titles to make it as appear as this is what he was putting out to the public, these words, and these words tell us what his intent was.
That's why that stupid intent files folder again. And I'm sorry, babe, even if you take it as this is just the way that they're wording it. And I think that that's what Bederow was leaning into in the Judge Gage pushback was you are thinking for the jury. You are telling them what to think. Here is the evidence for intent. And this one shows he was whatever it was, like it said something, make the O'Keefe's, I forget what the one, one of the ones that I was trying to remember that he had identified. And then you play a out of context clip. I'm sorry, all three of those combined puts a thumb on the scales of justice. Period.
100%. I mean, they're forming legal conclusions in there for the jury. You know what I mean? It's like
exactly.
Yeah. I mean, which obviously they can't do. So, I mean, whether or not the judge is going to have the ball.
And factual.
Yeah.
And factual conclusions when you combined it all together.
100%. 100%. So, I mean, look,
some of our
this thing's going to have to go to trial. Like that. That's all there is to it. And you know what? I mean, I just want to know that they're going to file, like, they are going to fight in terms of how much of the context of what was going out in the world or going on out in the world has to come in at trial. And it's going to be, you can foresee what a fight that's going to be. They're going to say, that's not relevant. That's not really, well, why is it relevant? Because it's everything. It's like, you can't get to this. Like, you can't get to the heart of this case without knowing everything that was going on.
And
we
that's
can't just assume because it was in Norfolk County that everybody knows.
Right.
I mean,
but that's
do
like
a
why
vast majority know? Probably.
What everything that you just said about the judge, and the way he's kind of seeing it or not seeing it or, playing that he doesn't see it affects what you just said. Where is he going to see the relevance on what information and the extent of that information that comes in? So that is a window into that hopefully, they're going to have to maybe shift the way they say it, or I don't know, but that's a battle for the lawyers now to have to think about and just flesh out what I've said to combine what you said so people understand what we're saying.
Well, why don't you flush it out?
Because I think I do a piss poor job of it. But what we're saying is, like, all Bob's points about what the judge isn't seeing when you put all the pieces together, the way Mark Bederow is putting them together, when at trial, as Bob just brought up, they've got to say, the defense has to say, this is how much of this clip needs to come in, or this is how much of this scenario they need to know about this other piece from over here, because it explains this piece is going to be so important, where a judge is going to be like, well, why do they need all of that? And why do they need all of that? And when you're worried about a judge not seeing the grander picture of things, then you're worried about the evidence getting in front of the jury, not encompassing that full grander picture.
Yeah. And
I don't know if I did that right.
Yeah, you did it great, per usual. But, the bottom line here is when this thing gets to trial, it's going to be very interesting, to your point, in terms of having like a window into this judge's mindset, which we do have at this point, in terms of what he's going to allow in. Because to me, there's almost got to be a trial within a trial talking about the investigation or lack thereof in the underlying Karen Reed case and John O'Keefe case. How do you have to be able to show that there's a reasonable inference that the people inside of that house had something to do with John O'Keefe's death at trial.
Agreed.
In order, and I'm worried.
Yep.
And I'm worried that he's going to keep it out. If he keeps it out, Aidan's screwed.
Right.
Because it has to come in.
Right. Because
it's that context that you cannot live without.
That's literally what we keep saying here. Like, well, how are you going to convince a jury that trying to get people to tell the truth is intimidation if you're not allowed to put in any evidence of what the truth is?
See, and here's the thing, in terms of the Commonwealth proving it up, they're going to have to put these people on the stand in order to say, oh yeah, I was intimidated. I was afraid to leave my house, blah, blah, like all that different shit is going to have to come in. And then obviously they're going to have to allow the defense to develop on cross-examination the fact of what you're talking about, because intimidation can work in two different ways, right? If they in fact did have something to do with John O'Keefe's death, okay, and Aidan's out there screaming at them with bullhorns to tell the truth, well, yeah, that's intimidating because somebody's trying to out
Expose
you.
Right.
Right. And in the other sense, if they didn't have anything to do with it, and they should be super upset with law enforcement because they didn't do a proper investigation and clear them, then that's intimidating because like, oh, well, this guy is like, saying things that aren't true. And like, we have no way to, well, yeah, you do. Yeah, you do. You could have gone and told Canton on the morning of or any time, hey, you know what? Come on in, check out the house. Like, here we have answers for all these bizarre things that happened, seeming coincidentally in terms of when John O'Keefe died. Yeah, we put the house on the market. Yeah, we did all these different things. Yeah, don't worry about Buchanan cracking his phone and throwing it away on a bed. Like, we have answers for all that, and this is what they are, and this is the proof as to why it was done. None of that happened. None of that happened. None of those things that would have potentially cleared them happened, and they did nothing to facilitate it. I mean, if it was our house, like, let's just go through this exercise. Had they, well, first and foremost, and I've said this a million times, and I will die on this hill, if they found a dead body on our front lawn and that person was supposed to be coming to party with us, they would have gotten a warrant, or they at least would have asked for a consent search. We would
they would have tried.
Would have done. Yeah. I mean,
I'm up on that hill with you. I don't care what anybody says.
Like, dude, that it's an argument for a judge to hear. Whether or not the judge,
they didn't even ask the judge to hear. Exactly.
That's the point. That's the point. So, but if it's us and we can see that the tide is turning publicly, like, because it's like a story that's out in the news and we're like, wow, babe, people think that we did some shit. Like, people think that we're like, what will we be trying to do to get out in front of it and be like, what? No.
Yeah.
No. Like,
take my phone. Not, well, wait a minute. I don't want to get anybody in trouble. Wait a minute. You don't want to what? What's on your phone that can get people in trouble? Why? Who are you protecting still? But that's not transparency. That's not, oh, sure, come in my house. Not, come look at my phone. It's like, oh, shit. They might find some shit I don't want them to. What?
Well, I mean, it could be completely unrelated to that.
No, because they said they were looking just for Proctor, just for communications with Proctor.
Oh, you're talking about now. I'm talking about like way closer in time as to.
Well, isn't that when all that happened? It was like, maybe it was later, 2024.
It was way later. It was way, way later. That wasn't until after like the feds looked into it and like, when they really trying to start to get into his shit. I'm talking about early days, and forget about them. I'm pretending it's us. That's what the exercise is. What are we doing? If like you see the shit, I'm going out there to all the different news media and I'm calling out Canton PD. I'm calling out MSP saying, well, you know what? They had every opportunity. Investigate me. Like bring it. Like, we have nothing to hide. The man didn't come into our house. Bring it. Like, consent search. Come in. Like, I can't help that they didn't do it in a timely fashion. That's on them. But I'm telling you.
No, I'm not letting the popo in.
I know.
Hell no.
That's the problem. Like, I mean,
lies are rough.
But, yeah.
But they are cops, so they don't think like us.
Who?
The should have been house suspects.
Well, that's for sure. Well, not all cops, but the one that owns the home is, so it's like, but that's the other part of this that you just can't ignore is that he's a Boston cop. Like, that part of it is just so fucking shady. It's like that thin blue line shit that like anybody who's not thinking that they're not protecting their own immediately. Like, that's what I'm saying. You've got to get out in front of it. And they didn't do any of it.
Right.
And I don't know.
A lot of people are in the chat saying, or some people in the chat saying that, but Aidan crossed the line and something. We're not saying that Aidan didn't cross any lines. That's not what we're up here saying. But lines that were legally witness intimidation under the statute, no. Vulgarity, sure. Inappropriateness, fine. But that's not what we're talking about here. We're talking about criminal liability under the witness intimidation statute, and I don't see it. Look, I don't know every single thing that Aidan did. I was not following all of that. That was like not my cup of tea. You know, I knew there was some like all this shit going on, but I didn't know everything that it was. But, you know, I pretty much know a lot of it now. And I know some of it, you know, is like, oh, that was somewhat uncouth, but not witness intimidation under the statute, under the law. And the fear is, as you're saying, babe, if the judge doesn't let enough of the facts in, then the jury just gets to think Aidan's harassing perfectly innocent people to distract away from Karen. They can't be left to think that. That can't be because then the judge is not. That's completely unfair. So the state gets to put on the evidence that, like, just by saying it, this woman was arrested for it. This woman was being charged with it. And he's out just willy-nilly picking random people to point the finger at. Because if that's what we get, that's some bullshit.
Yeah. I mean,
if the jury's left to think anything close to that, and like you're saying, you know, we assume that everyone there knew. And I kind of feel like at this point, I still want to feel like almost everybody does. But I guess you'd need some sort of poll. You know, but they're going to find a juror. That's the whole point of voir dire. That doesn't know all this shit. That doesn't know everything.
So DB says there, and if there is referring to the people that were in that house, thinking that the trial would prove their innocence, maybe. Well, my pushback on this would be they didn't do the investigation into the people into the house. They didn't go into the house and do anything that would satisfy me if I were a potential juror into thinking that nothing definitively happened inside that house because they went in and checked. Like there's the problem. I mean, the problem with this case has always been the investigation. Like it'll always be that.
And all the shady shit that they did after.
Well, right, but you know, like,
but it does all tie to the lack of investigation. It all
ties to the investigation, and I'm not even talking about the red Solo Cup shit. I'm
right.
talking, or the leaf blower.
Right.
I'm talking about the fact that they didn't do a proper investigation into the people in the home who John O'Keefe was supposed to be going into that house at night to party with.
They're still not, babe. They're still limiting.
They can't at this
point. No, but I mean, in the civil case, they're still limiting the discovery to texts that are about the investigation, about his death, not about what time, for example, did Colin leave the house? What time was he asking people about leaving the house? What was he talking about in the minutes just before leaving the house? Like it's you know, it's a lot.
It's a lot. It is a lot.
People
you know,
have some shit to say. Let's see what they're saying over here.
All right. Throw it up.
Well, Gray Space said, happy Mega Motion Monday. Thank you for that. Yes. And thanks for your continued support. I think we put this one up. Hope says, what the fuck? Another biased, corrupt judge who made up his mind. Grr. I'm going to stay a little more optimistic than that. Yes, it's a judge who made up his mind. I'm just hoping that he's more open-minded than he appeared from this, because he was at least educating himself with the law and putting some thought into what he was saying. So,
like when we're going to get that answer is when the motions in limine come as to exactly what he's going to allow to come into trial. Like, it really does need to be a trial within a trial. They're going to have to get into aspects. It has to be. When he says a trial in front of the trial, it's everything we were just saying about the evidence that actually proves that the house, or demonstrates that the house should have been suspects. Welcome, Andy. We know Andy, right? Of course.
Yeah. I mean, it says new member. I feel like
Andy's been in and out. Like what? We've had Andy on the show. I've been on her show.
That's what I'm saying. Like I didn't mean it. All right. So Julie Jensen says petitioning activity, Judge. Petitioning activity.
Love you, Andy.
Yes. What are the gems? Flow state. Sloth.
I think when I accidentally said it as a vertical live, like that's what comes from vertical lives. Like you may have changed it. Right? I don't know what it looks like on YouTube. You switched it. I'm assuming, but like that part of it must not have changed.
But we
'cause
weren't live yet.
I think you can only do the gems from a vertical
But
line.
we were, by the time we were live, it was supposedly, are we vertical people? Please
I don't know.
let us know. Thanks, Sloth Life. And thanks, Paxton. Finger hearts and all that. Happy poop. Gotcha. Love it.
Oh, that's the smiling shit guy.
Oh,
It's
Oh,
describing what
it's
the
describing
what
what
the
they're
emojis
doing.
are, right?
I was like, wow, Sloth Life. Happy poop to you too.
Wow.
Okay, with you. And then Bob gifted 5 Defense Star memberships, but
Palmyra Media
followed
came
it
right
right
back.
on up.
Thank you so much. We appreciate that. And so to all the people who received the free memberships.
Welcome.
Conzilla, love it. Aw, family hug. Welcome.
All right, now we're getting gems and sparkles and silver
Gems
stars.
and
And
stars
thanks, EJ.
and sunshine.
Now this whole gem thing, everybody knows about it but us. Here comes sunshine. Mac, 200 gems. Love those gems.
I don't even know what the gems do.
Maybe we get to
I mean, I
sell
know
them back to YouTube.
Well, no, like the gems have like a dollar amount. Like I don't know what it is though.
Oh,
Like I don't know if like 200 gems is. I don't know what it is.
$2,000. Thank you, Mac. Woo!
Yeah, I don't think so.
I
don't know.
Doubt it.
Yeah.
Soap API says, can someone turn on the fan in court so this clown can be gone with the wind? See
Oh,
what you did there.
I saw. Yeah, it was pretty good.
We seen it.
Pretty crafty.
All right, Angela, 200 gems, flow state.
Flow state.
I feel like everyone's in the know of something I'm not.
I mean, I don't know. Palmyra came back with another 5 DD podcast membership. Thank you so much, Palmyra. We really, really appreciate that.
And then Palmyra says,
oh yeah. The judge sent me some kickback. Just kidding, Judge. If you're scroll.
Kidding. Right, because we're literally in the process of getting approved, and I had to send links.
Yeah,
as media. So this comment's got to go. Actually, bye. No, I'm just kidding.
So this is
caller.
Thanks, Emma D. 350. Like I don't know what. Oh wow,
something's happening with the gems.
Chill.
Got more gems.
I'm assuming that was for Dave screaming Dave. Dave was in chat screaming.
Thanks, MS. Got that wild side coming out.
Oh yeah.
Oh man, 1,000 gems.
For fuck's sake. 1,000 gems. Goat trophy. Woo! The goat. Thanks. I don't know what that means in terms of money, but it seems like a lot.
Got more gems. They're all gems. Something's
this
happening.
Wild
with
side
gems.
is 10 gems like a buck. Like I don't know what the conversion rate is from gems to money. I just don't know what it is.
Got more happy poop.
Oh, happy poop.
See, we should have put this up because it was right when Bederow said it was a mic drop moment. So thanks, Crime Sleuthin. Love those gems.
We love them. 2 gems.
Yeah, maybe it's because
like a nickel. I'm gonna give him a nickel.
No,
there's a nickel for my thoughts. Silver star. Thanks, NH. New Hampshire to Florida. Made the trip. Thank you very much. Panda Bear, member from 1 month. Free speeches for everyone. Love you, Bob and Allie. We love you back. Thanks. Panda Bear.
And she makes a good point. Vulgar speech has long been determined to be free speech.
Yeah, everybody go back and watch. What the hell was the movie they did on what's his face? The dude, Larry Flint. People versus Larry Flint. It's a great example of how you got to put aside either the vulgarity or, in that sense, Hustler was seen as incredibly vulgar because it went way beyond what Playboy did. But, the People versus Larry Flint, and then, Larry Flint had said some shit about one of the televangelists. I can't remember who, but it's a very instructive movie to kind of getting you to put aside the words that are used in order to understand the concept of free speech. Because, like, you always have an avenue to run into court and sue somebody for defamation. So it's like that's what your remedy is. In terms of if somebody's using their free speech in a way that is not truthful, well, then you file suit, then you go into court and you prove that it wasn't truthful. Because, in the defense, the defamation is always the truth. So go watch that. It's an old one. It's got I think Woody Harrelson is the lead in that.
Oh, not
It's
Matt.
No, I think it's Woody. I think Woody was it. Let's see, McMuffin, new member. Oh, girl.
Wait, where'd it go?
What? Huh? What? Family hug. Thanks, McMuffin. We appreciate you.
Thanks, MS Wildside. And then, so Who Dares Wins says, should Aidan testify? I don't know.
Oh, God. I mean, the problem with putting Aidan on the stand is no matter how much you prep him, if you're Bederow and Bradle, you never know what he's going to do up there.
I think he knows at this point. I think he would probably make a very good witness, but I just don't know if it's, I don't know if it's good. There's all the cross-examination that who knows where it would go. What I think can a lot say of it is probably not.
Yeah, probably not. But look, that's going to be a game time decision. And when I'm saying game time, I'm talking about after the Commonwealth rests. They're going to have to look at it like, and it's going to go back to how much the judge is going to allow context to come in terms of what was going on in the outside world surrounding that case. And, if you get to the point where you're like, God, man, we got to put him on. He's got to get up there and he's got to be able to say his piece, which is scary. We never want to put a defendant on because of a multitude of reasons. And it has nothing to do with innocence or guilt. It has everything to do with perception. So I don't know. It's a tough call. Like if we were trying the case, it would be a call that we wouldn't make until after the Commonwealth rests, frankly, in terms of, and ultimately it's Aidan's decision, not his lawyers anyway, but certainly.
I think Aidan's gonna take his lawyer's advice. This isn't the kind of case where it's like,
I would hope so.
Yeah.
So
I think he trusts his lawyers at this point, at least,
Yeah.
Short Stack and Crystal Dale, welcome.
Family hugs.
Welcome. Got some more gems from Scooter. What is the flow state?
I don't know.
What emoji is flow state?
Go to put the flow state emoji into
I don't think
the
we
chat.
Can we see it?
I don't know.
Everything we're getting is
I can see it
describing.
I can see it on our, let's see. I can
go
see it on our YouTube chat. Let's see. Whoa, it's going so fast. All right. It's like trying to catch up.
And then we got Ramblin' Rome, gold coin. Like it.
A gold coin.
You got Laughing Disco. What is Laughing Disco? Is that like a face that's smiling with it? I'm gonna have to put all this into my, I'll start texting it later.
Yeah.
Oh Lord. Oh boy. We got 67 gems. 6-7.
Oh, wake the kids up. They'll love it. What does it mean? What is 6-7? I don't know. Why do they
keep saying it?
Oh, that's the whole point. You're not supposed to know. The boomers and the Gen Xers aren't supposed to know. It's our secret to torture you. Doesn't mean anything. Oh, it's from a rap song. It's like, I was like, what the fuck,
No,
man?
it was a guy at a basketball game.
What? It's all the things. It's all the things.
Now
it's none of the things.
Aidan testify. Get around court limiting background of the.
Right. That's what I was saying. Who dares? That's what I was like. But again, if in his testimony, he starts getting into shit that the judge has ruled that's not coming in, the judge is going to shut it down. It's
all right. Short Stack says best couple duo ever and smart.
Thanks.
Besides me and my hubs.
Oh yeah.
I love you too. Allie is the best. Winning.
Wow. Wait, is it a competition between you and me?
Yeah.
Charlie Sheen. All right. Tiger blood. Tiger blood, baby.
Keep that tiger blood.
Yeah.
Thanks, Scooter, for your continued support.
Always, Scooter. Scoots. All right. Christy Silo, 80 gems. Clock it.
I mean, I'll clock it.
440 gems. Thanks, Christy. Uncle Alert. So you know what Unk is, right? It's
Yeah.
like it's what the kids call like old people. Like, yo,
Yeah,
what's
I
up,
get
Unk?
it. You're definitely an unk.
What? That's
You're a white
outrageous.
ass unk.
Oh, I resemble those words. Let's see. Thanks, Crystal. We appreciate it. Hyperbole. Clever.
1,000 gems. Man, that sounds like a lot.
1,000 gems goat trophy. I love it.
Sounds like so much. Thank
It's
you.
such a mystery. I have no idea what the gems are. It's like such a fantastic little mystery that I'll have to try to figure out. Big Dog, new member. Oh, family hug. Welcome
Big
on.
dog. Oh, look at that little
Appreciate
dog.
it. Yeah, it's sweet little puppers. Sweet little puppers. You know, somebody said in our chat, like on Replay Crew, that the angle of my camera that they could see Nook licking his crotchal area. Is that true? Is that
I
true?
mean,
I was
not
like,
right
is that
this moment.
true?
Not right this moment.
I mean, how much of them can you see?
0.
Right. Like, I don't, I'm like, wait. could you
Sometimes I
hear
can
it?
see him. Like when he stands up, I can see him.
Yeah. But that's like, you can't see him laying there. I'm like, nobody
I
needs
hope
to see that.
he's not licking anymore.
No, he's
What
pretty
day was
much
this?
not like it was a while ago.
Oh, okay.
No, I mean, it was like, I think they were referring to like a while ago when he was going through his licking phase, which,
Oh.
you know, we told everybody about. Poor guy in his psychotic licking. It was so much licking. We tried all of it. We did all the things.
All right, move on.
All right. Sue, 200 gems.
Thank you.
Sunshine.
Love those
Aw.
gems and sunshine.
Oh, thank you, Sue. High anxiety, 550 gems. Stay hydrated, my friends. Excellent advice. Hi. Thank you very, very much. 800 gems from CM Linehan. Turn it up. Like, is that an emoji? Like, I don't get anything about what.
All right, Unk.
Are these like little phrases? Okay.
No, that one seems like she typed out the words. Turn it up.
I mean, maybe. Like, stay
Oh, wait a
hydrated.
minute. Blessed Mom from Tennessee says it's a new way to support creators. Allie, I got a heart and it works.
I got on HRT and it works.
Oh, for maybe perimenopause. Not to out her right there.
Oh, so she was throwing in all kinds of like tips there. All right. Stay
HRT,
hydrated. Yeah,
look
see,
into
that's
it.
clearly a thing, like a drop-down menu predetermined thing that you can type in.
We're
there.
gonna have to
Stay hydrated.
investigate this when we get
I
off
mean, we're
this.
gonna. Oh, thank you, thank you, Java Monster. We appreciate it. Yes, Jerry Farwell, right? Was it Faldwell or Farwell? I don't know. I can't remember.
We'll go Faldwell. We'll just read what she
Faldwell.
wrote for now.
Yeah, Faldwell. Thanks.
More
Mom.
laughing disco.
The laughing disco.
What the hell is a laughing disco?
I mean, it's clearly a disco ball with a smile on it.
Oh, a husky. That's like Nook.
Aw,
Kind of.
800 gems. You guys are crushing it with the gem game. I don't even
mean-
know. Like, I wish I knew what they were. I wish I knew how excited I should be about the number of gems that y'all are throwing at us. It's like, I just have no idea.
So many gems.
Could be like a total
and
of $5.
sunshine.
Yeah.
No. Hey, Foxy gave us $1.99. See
Oh,
that?
yeah.
You know how to interpret.
Oh,
Thank
yeah.
you. Thank you, Foxy.
Thank
We
you,
need to
Foxy.
find a way for feds step in corrupt. Yeah, I mean, but you know, don't always trust the feds. I'll just tell you that.
Tracy's probably in our chat explaining.
Yeah,
to me
telling
how
us
it
shit.
works.
Hey, happy poop.
Oh, it's like, oh, okay. So it's like Trace says it's like $2 for 200.
Oh,
All right. So, oh yeah. Look, I'm looking at it. She sent it into our chat thing. So you got
that
all
means someone sent $100 or is that $10? No, 100 for $1. Oh,
if it's like $2 for 200.
so that was $10.
Yeah. So 1,000 is like $10.
Very
Ooh, a
generous,
gold
you guys.
coin.
Thanks. Nah, I don't buy it. How did this person send 2 gems then?
What do
They
you
don't
mean
let you
10
send 2
gems?
sex, 2 cents.
Whoa, Freudian slip.
Yeah,
Take your mind out of the gutter.
all the sparkles.
Mind, gutter, remove it.
2 sex.
Oh boy. Wow. High anxiety, 2 gems. That's got to be like a nickel.
That's
Thank
what
you.
I'm saying. I don't think they let you send a nickel. That's like would be 2 cents.
Here's my 2 cents worth. Oh yeah, 2
We're
gems.
gonna figure this out.
I don't know. We'll figure it out.
High five.
Figure Uncle Alert. That's another one. There's the
Melissa
Uncle Alert,
Filson.
the Eagle, the Flow State.
Wait, is that a
Hydrated.
picture? Are you seeing them?
Honey, go into our chat and Tracy took a screen grab.
Stop acting like you figured some shit out.
I didn't figure shit out other than I can see what the things are referring to. The goat trophy, the laughing disco,
I think Tracy
the
only
6,
sent it to
7,
you.
let him cook, sunshine, tube dancer, tube dancers, that thing.
Oh.
You see the promotional thing. It's, got the air that you see at car lots a lot. Oh yeah. Oh yeah. Now she's seen it. Melissa, thank you so much for the 100 gems. High five. Happy poop. Thank you so much, Paula. Clapping seal. Wow. There's a lot of gems out there, huh?
Oh, that
clapping seal. Wow,
tube dancer.
Yeah, I just told you the tube dancers, that guy. You drive by a car, the inflatable dude.
Yeah,
that shit. Yeah, that guy.
Stay hydrated.
Oh, my friends, stay hydrated.
It's a little turtle. Goat trophy. All right, now I'll follow along.
Okay. I don't know where we're at. Clapping
seal.
seal. Where was that? Oh yeah. Happy poop. Thank you very much, Mary.
Oh, that laughing disco ball is adorable.
It's so cute. It's just it's like a disco ball that's laughing. It's adorable. Yeah. Mary came back with 440 gems. Uncle Alert.
Yep.
Uncle Alert.
Bob and I go back to our
happy poop.
Chart.
Thank you so much, Mary. Paula, thank you for the happy poop. 1,000 gems. Racing Queen. Goat trophy. Love it. I love it. That's fabulous.
Racing Queen.
Now we know what this means. Sandy gifted 10 DD podcast memberships. Thank you so much, Sandy. We appreciate that so very, very much. We love it. We love it. Who Dares Wins came back. $2 jury selection. Younger, better. I would think so.
I think so.
Like you need people that understand the internet and social media for sure. You
so
can't
no
have
Bobs.
you cannot like I understand it. Like you can't have Bob seniors. No Bob seniors.
No. I'd say no one over 50.
So we watched that movie Obsession last night, and my dad's like, "Oh, I should have banned this. This movie should have been banned."
I told him, "Do you got some books you want to burn?" That's what I asked him. Got some books you want to burn, Dad?
I'm like that actress that played the girl who had been, the broken willow branched. Like she had the voodoo on her. It was fucking awesome. Like she just crushed that role. Like hate that movie or love that movie. Like she has to be nominated for an Academy Award because that was great. She was great in it. Like she made the whole movie. Without her, that's like a C movie. Like if they put somebody else who kind of like sucked in that role that didn't go full crazy.
Right.
She went full crazy in it and she crushed it. So,
thanks, Mrs. Jägermeister.
Wait, Miss Jägermeister.
Did I miss a bunch?
Oh yeah.
I missed a bunch. You're right.
Adventurous Mel, 10 gems, gold coin.
You go. You take over.
Thanks, Miss Adventurous. We appreciate that. That girl is poison. Gold coin, 10 gems. Thanks. Miss Wildside sent us a nickel with 2 gems, silver star. Thank you so much, Miss Wildside. I mean, if the numbers that Tracy said, like 200, I don't think Tracy was saying this in stone by any stretch, but she's like 200 is like $2. So 2 has to be like a nickel, right? It's got to be something. I don't know. I don't know what it is.
We appreciate it.
Yeah, we do. Either way.
I mean,
Tracy
everybody's sending little pictures and gems. So
Yeah. it's
Oh,
adorable.
wow, Trace.
Ooh,
Thanks.
thanks, Trace. Special
Give it
girl.
back to yourself.
2 gems, 100%. 2 gems. That girl is poison. Thank you, thank you, thank you. Jedi Jen, a goat trophy, 1,000 gems. Did the gem things now work? Like it doesn't have to be vertical. We're gonna have to research this. I don't even
All
understand
right.
it.
Yeah,
It's like
we've said it.
the
We've made-
weekend. Like I'm still just mystified by it all. Miss Jägermeister, there you go. Flower, 30 gems. Thank you.
I mean, I drank me
Mrs.
some
Jaeger.
Jägermeister back in the
Oh, I bet you have.
90s.
I don't even believe that because you hate the
I know, but I
taste
did.
of black licorice / anise.
I know.
When would you ever have had that?
I did. That was like my shit. And
What?
Goldenschlager, which is like the same thing.
Goldschlager was like a intensely cinnamon flavored schnapps.
Oh, that was cinnamon? Okay.
Yeah, like intensely cinnamon, very cinnamon.
Mix the two, Goldschlager and Jägermeister.
Oof. Jägerschlager. Oh. Okay, that girl's poison came back with 2 more gems. Sparkles, thank you very much. Kitty on the beach, 200 gems. Flow state.
Kitty on the beach.
Thank you so much. Paula, 100 gems. High five. Thank you, thank you, thank you.
Where's fist bump? They don't have that one.
Misadventurous Mel, 100 gems. A Sunday. Ooh,
yummy.
delicious. Tasty. Mrs. Jägermeister, 10 gems. Flowing heart.
See, I don't think we need to read these, maybe.
What? There are people still giving the love. Yes, we definitely have to read them. Don't see
pictures.
See, Allie got there. Oh, you mean in terms of what it is?
No, but we have to because that's what it says.
Oh yeah. Oh yeah. So another 10 gems from Mrs. Jaeger. Appreciate you. Casually Kiki, member for 7 months. Booyah! 7 months. Thank you, thank you,
thank you for your continued support.
We love it. We love it. Oh,
we got
a lovely and talented ATS News. $2. Love the modders. Hit the like. Thank you so much,
thank
ATS. You. Love you back. Ashley Bouchard, 67 gems. 6'7", 6'7". Kids
Wow.
love it. Wow. YouTube, like a year late on it.
Right.
Shit.
Yeah. So fucking late to the game, YouTube.
Ashley Borchard, 200 gems. Flow state. Now, flow state's new. Flow state is the new. So that's.
I'm in a flow state. I'd like to.
You are the flow state. You are the flow state. Thank you so much, Ashley. And then Rachie, 1,000 gems. Go trophy. Thank you, thank you, thank you. Laughing Disco, 250
gems. Go on forever.
I mean, it seems like it's going on forever. But I mean, it's like it means something. Like it translates into something somehow. I don't know what it is. And the kids love it. So that's all I know. Clapping seal. So Shannon came back twice with 250.
I gotta see how everybody else is dealing with this.
It's a lot. It's a lot. All right. So let's see.
You just stay on for hours reading pictures.
Katie, 100 gems Sunday. Thank you very much.
Still loving
Mary
that.
came back. She likes stay hydrated.
It's important.
Stay thirsty, my friends. 550 gems. Appreciate that. Uncle Alert. Seems like that's a personal attack on me. I don't know.
For sure.
440
Iceman says, "What up, though? What up, though?"
Oh, see, thanks,
hey, Iceman,
for keeping it on the reel. What up, though, man? What up, though? Good to see you. Thanks for the generosity, as always. All right, are you looking at the chat? Like people are screaming at us. Like I'm 500 chats behind because I was going through all the starred shit. They're screaming at us, like telling us we're missing shit. Something huge is happening.
Wait, there's cupcakes here? Oh no, cupcake. You're welcome. That's one cupcake.
Oh yeah. Oh yeah. Oh, our heat finally broke. Finally. It's like it's reasonable out. It's kind of
me. I will never get my nap, but maybe DD will get their studio.
Oh yeah. Oh yeah.
Gems. The gems are for the studio.
Oh yeah.
Gemmy.
I mean, all of it is the Venmos, all of it, all of it.
Oh, better get on those.
What I'd like to do is build our diner studio for the morning drop. Like that's what.
Well, we're supposed. That is literally on you. I keep telling you, get the guy to build the studio. Like I don't know what's taking you so long. Like, call the guy to build the studio.
Okay, babe. All right, we got some. Let's see, we got a couple of Venmos here. All right, so and by the way, we are definitely going to be covering the Lindsay Clancy trial. I don't believe like I didn't see anything. They're supposed to be picking the jury today. That's starting today. So we'll keep updating on that as we learn more. I don't think that they're streaming the jury selection, which is not unusual. I would have really I would have enjoyed watching it, to be honest with you, because this is a tough one. It's going to be a tough one to pick a jury for. That's for sure.
I got to deal with the dog. Love you guys. Bye-bye.
Wait, the dog is right next to me. You're lying. She's just been made out to be a liar. Lies.
What is that noise? Then I got to go investigate. What's
this guy's? What's she going? She going. All right, let me do the Venmos. Let me see what's up with the Venmos. We got some Venmo love, which we always are very thankful for. Okay, we got some Venmos today. Let me make sure I'm not. Thanks for the TB stream 25 from Cynthia. And remember, y'all, if you don't want me using your government name, you got to put what your screen name on YouTube is. Otherwise, and I still screw that up sometimes. Sometimes I don't read it all. Like now that Ain't So Plain Jane sends Venmo so often. I know what her screen name is. She sent $10, said, would it be smart for the defense to call Mello? Thanks for the live. I mean, it depends on what they're going to allow in. They being the judge, right? Like, how much are you going to be able to get into that stuff? I think, and the other part of it is when you're calling what I would consider to be an antagonistic witness on direct, it's hard. It's different. It's a different thing. It's like, because it's not like it is in the movies. You're like, oh, Your Honor, I want to treat this witness as hostile, and you get to start cross-examining. It's a bigger analysis than that. So I don't know because I don't know how it would work out. But you may need to. I mean, you might have to. But like, you understand the difference between direct examinations, which are where you're asking open-ended questions, and we're in with cross, you're asking leading, where you can really, kind of pin them in to an answer, either yes or no, where they can't go too far afoot. And as you can imagine, when you've got a witness that is not friendly to you, that's a challenging thing to do on direct. So I don't know. It's like, the way that this trial is going to play out is going to be really fascinating to me. Yeah, they were asking about Mello. So thank you so much, Ain't So Plain Jane. We really appreciate your support via Venmo. GA Catmom came at us with 5. Thank you very much via Venmo. At this point, I trust a jury more than any mass judge. Yeah, 100%. 100%. Like, no question. Like in if it's Suffolk, if it's Norfolk, any of those counties, I'm going jury. If it's surrounding this particular type of case, like anything in the Reed universe, which at this point, I consider anything that Rosemary Scapiccio is going to be handling within that universe because of the Proctor bisection. We've bisected with Proctor. Proctor has entered the team photo like in every case that's ever touched his greasy hands. So, yeah, I mean, bench trials are scary though, Amanda. And that bench trial was on I think on an RO. This is different. Like, is that what you're talking about? His bench trial? If you're talking about like a thing like for a restraining order, I don't know that you can get a jury for that. Can't in Illinois. Thank you so much, GA. We appreciate you. And Dog Grooming Danny threw 10 at us. She says, I can't stand TB's lives. He's an ass. However, he is intelligent and interviews well, and I think he could maintain himself on the stand. I mean, that's the $1 million question. It's not so much how he's going to be able to maintain himself on direct. He'll be fine. It's how will he compose himself on cross is what you worry about. You know, I'm telling you, that's gonna be a game time decision. Like, they are gonna figure that out after the state's case is rested. And, they'll be discussing it. Look, Bradel and and Mark aren't going to be mincing any words with Aidan. They're gonna be like, dude, like, you have like a real problem with shutting the fuck up about shit that you need not be talking about in consideration of where we're at in relation to your trial. Like, you're making things harder potentially on us in terms of defending it, because, like, they're going to be trying to put all kinds of shit, all kinds of clips in. Huh? Oh, Allie says the longer I take, the more gems we're getting. Wow, is that how that works? Got to read the pictures. So thank you. Yeah, I mean, yeah. I mean, it's a tough question about whether or not he takes the stand, but it really, again, it's going to depend on how the state's case went. All right, let me check PayPal. I saw people screaming about PayPal a little bit in the chat. Let me see what we got over there. Oh my God, of course I'm not logged in. And I'm sure this has some super old password. Okay. Oh yeah, that's ancient. It's an ancient password. I don't know. Let me see. Okay. I want to take a guess. As you can imagine, I'm not real good with passwords. I can't get to it there. And I'm not going to torture y'all by trying to figure out what the hell my password is. Here's my promise. If, let's see. I don't even know if I've ever gotten into the PayPal. All right. If you sent via PayPal, yeah, I do have a password manager. No, I won't. I won't say it out loud. But like, it's got old shit for some reason, like an ancient, really, really old. See, and I got a new phone, so some of the passwords didn't carry over to the new phone. What I promise is, if you sent money via PayPal, I will give you love on the next stream. I'll go in and I'll find it. Yeah. So the name of my dog, Nanook. Nanook. Are you new to the channel, Crispy? It's our guy. Nanook of the North. You can call him Nookie. You can call him Nook. You can call him Nook. You can call him the guy. Oh, yeah. Oh, yeah. All right, let me check one last thing on Cash App here. Oh, but so again, look, y'all, you got to watch the Lindsay Clancy trial. I know it's hard. I know it's just brutal. It's so brutal. The facts are just awful. They're unimaginable. Such an important trial. It is such an important trial. People need to pull their heads out of their ass about mental health and mental illness in this country. Like, and that is it. That, like, the trial is going to be surrounding that. I saw that Matt Timpanic guy who's allegedly a defense attorney writing some shit about, like, oh, I can't wait to see the defense try to blame from my shooting. I'm like, this guy is not a defense attorney. Like, if he is, if I'm a defendant, I'm running in the opposite direction, because he's got bad takes on, like, and I don't get if it's just his grift because he decided to be the anti-free Karen Reed lawyer in order to try to build his platform. But I mean, for a career move, I don't know. Doesn't seem smart to me. I don't know. So I hope you'll be watching that with us, because it's important. It really is, and like, a majority of the trial is going to be the battle against the doctors, about big pharma, like the medical providers that failed that, not just Lindsay, the whole family. you know, and it's like all those questions. Yeah, well, didn't the husband know? And like all the things. And, you know, I saw somebody saying, oh, she didn't say that she heard voices until 2 days. That's not true. That's unequivocally not true. You should go back and watch our live wherein we read Rosemary's complaint because they're suing all the medical providers and the doctors involved. She was telling everybody everything. Like she wasn't hiding shit. She was like as open and obvious, begging, pleading, doing everything she could to find somebody that could treat her properly, to stop what was going on with her. And they just weren't. And they weren't working with the one. It's insane. It's insane. I fully blame the healthcare industry on what happened to those kids. Like if you don't understand psychosis, if you think that psychosis means that you can't put two logical thoughts together because you're psychotic at every moment of every minute of your day, you just don't understand the disease. I don't know what else to tell you. That is not how the disease works. Like people, you watch too many movies. You're not frothing at the mouth, scraping at walls, plucking your eyeballs out. I mean, psychosis comes and goes in waves, and you have no control over what your mind is telling you is reality. There's no way to delineate it. You can't just say, oh, it's the psychosis talking. It doesn't work like that. It's an important trial. I hope you all are going to watch it because you need to watch it. It's that. Are you doing Zach Adams' appeal denial? Yeah, at some point I've got to first stop being irritated by it. But yeah, we'll go through it. I'm not gonna I know Kat read. I think her and Katie read a bulk, if not the entire thing. I'm not going to do that because it's like 98 pages, but we're going to definitely go through it and talk about what the next steps are potentially. Thank you so much for that, Iceman. We appreciate that. Oh, Robin loves Mike forever. 10 gems. Happy poop. Oh, sweet. Controllable? Did I get it right? I feel like I did it. 400 gems. Eagle. Thanks so much. Appreciate that. And then Angela Castillo, 350 gems. Finger heart. Oh, thanks so much. All right, y'all. I thought that Mark did an excellent job given what the judge was allowing him to get into. He made his record. Which is important. I think Mark was able to get enough out there to preserve the issue for appeal. God forbid it's needed down the road after a conviction. Looks like another Venmo came in before I dipped. $5 from Jennifer. Thank you. We appreciate you so much. According to Court TV, what? I'm missing it. I guess there was a witness shakeup for the. What does that mean? So I know, like last minute filings, there was a motion opposing the defense's, a couple of the defense's expert witnesses. And I know that the defense responded to that. So they're trying to bar these witnesses due to late disclosure. The Commonwealth is. So I don't know if they're arguing that now. Is that what you're saying? Is that what the deal is? Is that what the deal is? Let me know in chat. Oh, the judge allowed the Commonwealth's motion. Wow. Was that streamed? Oh, shit. All right. Well, we'll definitely be covering that as well. All right, you guys, we love you so very much. Mods, thank you so very much for all your hard work on the daily basis. We love all of you. Tracy, we adore you. I hope your birthday weekend was spectacular, truly. And if you are new to the channel, please remember to like, share, subscribe. We're like 200 away from 70,000. Help us help you. Help us help you. Spread the love about the channel. It's free. You can do it. You really can. It's free. Do it. All right. I love you guys. If you're on replay, make sure that you leave a comment in the chat because that helps get it out there. And then hyperbole. Remember for 6 months. Family hugs. Appreciate that. All right, y'all. We love you so very, very much because without you guys, I'd literally just be an old man talking about a whole lot of cases. Talk to you later, maybe even today.